Sorry, the documents on item number 30. For the day. I already informed. The date may be fixed. Item 30 is submitted that the counsel for the petitioner, hearing counsel for the petitioner, Mr. R.K. Sharma, and therefore seeks an adjournment for 2 weeks. Still appearing for the bank, Mr. Ganguly, the other submit. That will be listed on a fixed date. 21st. Well, I will give you 14. Well, 21st is better. 14, there are 20 matters. 21st. Interim order passed, if any, will continue till the next meeting. Deeply obliged.
The concept of the arbitration item for an adjournment lordship on the ground of bereavement in the family of the arguing counsel, Mr. S.P. Shankar.
My lord, I am appearing for the private respondent, my lord. The adjournment may be granted, but a short date may be given, my lord, because it's a long pending matter. The promotion of the petitioner is being asked.
11 on the submissions made that the arguing counsel, Mr. S.P. Sharma, will be again on 21st. Interim order will continue in the next meeting.
Obliged, my lord.
Please, Lord. My lord, this matter is covered by a judgment of the coordinate bench, my lord, upheld by the division.
Which matter?
My lord, this matter was, my lord, for admission was posted after 2 weeks, my lord, the month of February, but not listed till date. So, my next week, any date, my take it up. About that.
Did it come on 4th? 4th of May.
Please, Lordship. I get to make item number 20, Lordship. Any matter may be adjourned for the day, Lordship. We are taking concern of the other side.
You're for the
Petitioner.
item 20 submissions made.
Concern of the other side, like to mention item number 25, matter can be adjourned for the 25.
25 on the request made by the council.
Admission column.
How does it matter whether it's admission or hearing? You mention it.
Right, with the concern of the other side, I'd like to mention item number 15. They have some difficulties.
Item 15 on the request made by the council for the stands before still up.
But I got on 14 of May, man.
No date.
2 weeks.
2 weeks.
On the interim order is there.
Past 30 will come.
What's my recommendation for litigation matter? The admission column on 28th.
Why?
It was last posted on May 2025.
Why we selected each day? For what purpose?
Any day on the next week.
All right. Let it be on 4th of May.
Much better. I get the instruction from
the submissions made by the council that they did press the petition further. Stand dismissed. There's no press. MS.
Are they appearing on behalf of SS Roy?
Mr. SS. Interim order, we can stand the ticket pending. P. Nayak, Additional Advocate General, is leading us in this matter. Mr. P. Nayak is leading us in this matter. He has some medical difficulties appearing to be. I adjourned the matter for the day. For what purpose was it kept here? You filed some additional evidence. And the made a statement that the regulation, whatever was called in the year 2005 itself, that whatever was not placed for this school, the other litigation. There is made on behalf of the Government Council, Mr. Additionally, Mr. Naik. Option 6 and accommodation. Stop. Step 10 referred to be listed on 12th May. Only paying and last product dated 6/3/2020. Where is Mr. Chisti? Education Department. Yes. Why is it? But what has happened is now it is court order funding by cannot be taken. Yeah, no, but that endorsement has to be there by the registry that bench, regular, the rostered bench can't take up the matter. Nothing here. But in the causes, just mentioned. The things brought before honorable justice you can. So the education department here.
But Mr. SN is not in the group.
Matter was fixed in his presence. He was appeared before the court. At his prayer, the matter was adjourned and fixed. Should take alternative steps, alternative arrangements to ensure.
He might have missed the matter. He might have missed the matter.
Talk to him, find out. We'll call up after a while. You take you see the last order. Talk to the standing council, find out what orders are. He was given time to apprise the court. Find out. We'll call up again.
Non-time on PCIC. The petitioner husband has expired, who was in Khalasi, the office of the respondent number 0. And his service was regularized. During the service period, he expired. And pension already given, but PCIC has not been.
Which department?
He's
PHC.
executive of PHC Haplong, Hima Hasao and Hima Hasao. And accountant general, I have filed an RTA before the accountant general, that is space 18 lordship. Reply of RTA from accountant general. That see in his office on 24/9/2019, I am to state that the net qualifying service of a husband, late Mahabur Rahman, stands at 18 years 4 months and 16 days after deduction of 3 years of works or service from the gross service period 21 years 4 months 16 days, which is below the benchmark qualifying service of 20 years of entitlement of other pensionary benefits like DCRG. However, service of a late husband was also not confirmed. Hence, you are entitled for not entitled DCRG, but family pension has already been authorized. But profit as per service pension service 150 rules, only 5 years is needed. For the service 5 years now.
Yes.
My lord, I have received instructions in this matter, my lord. I'm seeking the 2 weeks time, my lord.
Poor matter.
My lord, it is actually, my lord,
Then it was sent for mediation. Mediation failed. Why did it fail? We refer it back to mediation. Get complete your instructions, attend, and attempt to sort out this matter. The name of your
Mahabubur Rahman. Mahabubur Rahman. Borbuya.
Mahbubur Rahman Barbu. He died in harness.
Was
Expired. He died in harness 16/10/2003 by service. The grade 4 fallacy. Executive Engineer Public Health in Haplong. Pension, sanction and family pension. CRG has not been granted. Stock representations filed. Response. And subsequently, on an RTI application being filed before the authorities, the petitioner was informed that the net qualifying service of a husband stands at 18 years, 4 months, 16 days after deduction of 3 years of work charge period from the gross service period of 21 years, 0 months, 16 days, which is below the benchmark of qualifying 20 years for entitlement of pensionary benefits like DCRT. Therefore, it was held that the petitioner is not entitled to, petitioner's husband is not entitled to DCRT. Or rather, petitioner is entitled to DCRT. By order dated 28/8/25, the matter in 2025 reported that the mediation was unsuccessful. Only mediation was conducted on the following days, so they have decided to pay. However, a report as to why the mediation failed and the therefore not available in the mediator.
Point, may I point out? Well, actually, maybe we are not supposed to write that in the report.
However, we don't know why it has failed. Nothing is
One
there.
line has to write that it failed.
So we are referring it back to mediation. Considering that the matter has been pending before the court since 2024 and the respondent PH has not filed their counter affidavit. Stop to pay also when the matter is called up. Learned counsel appearing for PH. Water resources, sir. Water resources. But it is written here as PHE. It said PHED. You are representing PHED or water resource? This is PHED. Who represents?
I am my lord for PhD, but the petitioner is under counsel, my lord. His employment is under the counsel. It is a transfer service.
Mr. Rai Botabu. And also submitted by Mr. Botabu, counsel that the services of the petitioner is under the council, that is the Mahasa Autonomous Council. The Mahasa is not added as a party.
He was added.
Huh?
He was added.
Added? Where?
Yeah, this, my lord, executive engineer of Dima Assam, my lord, he is under the council.
Name also shown. SC Dima also shown.
No, in your post title, have you arrayed Dimahasa as a party?
Not Dima. PHC Dima also is under. Sorry, PHC a public health design is under Dima also. How from?
Submitted in the past that executive as the council subject. Considering its facts, matter is demanded back for mediation. Expected that the matter, that the dispute will be resolved by the mediator of the Gauhati High Court Mediation Center. Stop matter being listed. Parties will appear before the Gauhati High Court Mediation Center on 8th of May.
Please, as per my instruction to the draft service will still pending before the higher authority of the department. It's not placed before the cabinet.
Heard. Counsel for the parties. You were supposed to satisfy the court.
Can you see the
First.
Yes, my lord. Can you see the order dated, my lord, Regarding the paragraph 24, man. Page 3, my lord, last paragraph.
This order,
Yes,
there is no paragraph 24.
my last paragraph, page 4, 3,
Yeah.
my lord. Out of 4, page 3. My lord, the question was raised, my lord, earlier, my lord, regarding the, my lord, compliable issue.
The same matter.
Same matter, my lord.
Why are you giving this order? This order is already here.
My lord.
Why are you giving us this order?
Well, so many orders, my lord.
So tell us which date order you are referring to.
My
Which
lord,
order?
order dated, my lord, 2024, 22, my lord.
What is it?
My lord, regarding the paragraph 24, my lord.
24.
24 of the judgment, my lord.
Huh.
Judgment dated,
The judgment which according to you
Well,
directions have not been complied with.
my lord.
Yes, there are 24.
There are 24.
22.
24, my lord, page 14, my lord.
Page
Page 14. Regarding the issue of consideration, my lord, whether the, my lord, this contempt petition is, my lord, maintainable or not.
The question put to you on the last date was not whether contempt petition is maintainable. The question is whether the court can direct whether amendment of rules, new rules falls within the domain of a policy decision.
No, my
And
lord,
when
but-
it is a policy decision, whether the writ court should issue a writ
well, it seems
to
that-
the government
well, it
to
seems
take a
that-
policy decision in that
well, it
context.
seems that frame a draft rule that is to be placed before the cabinet, my lord. That is up to them, my lord. Let them to place before the cabinet, and after placing the cabinet, my lord, my case, there is no case.
They have already, we are referring to the directions at para 24. State government should consider giving promotional avenues to so and so within a framework.
My lord,
And then 23,
my lord,
as much a new post may be created.
my lord. Then 20.
So, the order that you're pointing out
My lord,
in 2.2, have you read this order?
my lord.
Please read it again for our benefit. Start from the third paragraph.
In this regard,
No, third paragraph. In support.
in support of the contention that the aforesaid judgment is not compliable, the learned counsel of the respondent number 2 and 3 has placed lines in the case of Union of India versus so and so, and it is submitted that whether rule is required to amend or whether policy decision should be taken to promote extra writers to be next higher post to be created is within the exclusive domain of the executive. In this regard, the court is of the considered opinion that being a coordinate bench of the equal strength, it would not be in the interest of judicial decorum to take a contrary view than what has been opined in the hearing before referred judgment and order dated 9/11/2020.
What is the meaning of this? What is the view of the court?
Then Then
No,
my
no,
lord,
up till now, whatever you have read,
my lord.
what is the view of the court?
Well, court's view is that, my lord, the court, my lord, court, my lord, is not in a position to, my lord, interfere, my lord,
If you try to twist whatever is there in the order, we are passing an order referring your case for consideration of disciplinary action to the bar council. This is an order of the court. You read it and interpret in the manner it is given. Do not try to twist the words of the court. Either you have not understood what is written, or you refuse to understand what is there because you want to urge your case in a manner you think it is proper. The court has given a finding that the order of the single judge is contrary to the Supreme Court's view. And you want compliance of this order. And you are arguing the case that this order has to be complied, failing which contempt proceedings are to be drawn up. You must take time to go through the statute. Have you gone through the Contempt of Courts Act? What are the High Court rules of contempt? Third, counsel for parties. This contempt petition is filed by the petitioner. The judgment and order dated 9/11/2016 passed in WPC 3109/2015. The writ petitioners in the court were extra writers in the registration department, Government of Assam, engaged on a daily wage basis. By notification dated 1989, the extra writers who had worked continuously for 7 years were regularized with the scale of pay of 470-800 per month. Subsequently, the procedural direct recruitment of extra workers was done away with by the Assam Public Service in the direct recruitment to grade 3 before rules 1997. Stop. It was the case projected by the counsel for the petitioner before the court that they are not included as a heir in the Assam Registration Service Rules of 2010. Under the Assam Services Revision of Pay Rules 2010, the extra writers were shown to be a cadre under the registration department. Therefore, it was a case projected before the court that since the Assam Revision of Pay Rules 2010 had clearly indicated the extra writers to be a cadre within the registration department, their promotional avenues to the next higher posts, higher cadres, are required to be prescribed by the department. Stop. Matter ultimately came to be disposed of, and the court had passed the following directions. According to the petitioner, since no steps were taken in terms of the directions, the present contempt petition will be filed. Therefore, there is no direction that the court had accepted contention of the petition is that promotional avenues are to be prescribed for the extra writers, and for which the state government will have to consider modifying 2010 service rules. So, subsequently, during the pendency of the contempt case, the respondents have filed that of the framing of a new service rule is presently pending at the highest level, the state before the cabinet, state cabinet. That apart, it was urged that since this falls within the exclusive domain of the state and is a policy decision, steps undertaken by the state to frame the draft rules and which is pending approval by the before the cabinet will be sufficient compliance of the directions contained in the order. Of India versus All India Trade Union Congress and others reported in so and so. The Ethics Court, by deciding the question of framing, examine the question of whether the writ court should entertain proceedings which fall exclusively within the domain of policy decision. Ethics Court held that where policy decisions are required to be undertaken by the state, ordinarily any court is not required to entrench on the domain by issuing writ to the state to undertake policy in one way or the other. So, this view of the ethics court has subsequently been followed and fortified by several other announcements of the ethics court. So, coming to the context of the present content, seems that the direction of the coordinate bench is to the respondents, namely Chief Secretary, Former the Commissioner and Secretary, Government of Assam Revenue Registration Department, the Inspector General of Registration Assam, take all steps for framing service rules. So, it's new service rules, it's draft service rules, which however are not available before, are in the form over 309 rules. Article 309 rules, and therefore are presently pending before state cabinet for its due. When any rule is proposed to be framed under Article 309, necessary approval required to be obtained from the state cabinet. It's not in the form of any application or referendum required to be issued by the department or within the exclusive domain of the department. Therefore, in the understanding of the court, the state respondents have taken the necessary steps as per the directions contained in the order dated so and so past in the for framing set of which, however, as stated, is pending approval state cabinet. Whether the state cabinet will approve or should approve one manner or the other, not for the writ court issue any corrections. Any contempt proceeding. Specific orders are called for. Supplementary specific order called for. Addition to the order which will be alleged to be willfully, deliberately violated. So, under such circumstances, and in view of all the above discussion, this court finds that no contempt has been made out at this stage. Therefore, contempt petition stands closed. Purpose will be served pursuing the contempt petition at this stage. Stand below. Dispose.
There's
Mr.
my apology.
Both the Hendik and Borbudari legs, they couldn't have.
Mr. Hendik for revenue. Mr. Borpujari for
Mr. Hendik for one
respondent one. N.
and R Borbudari for
R. Borpujari.
Earlier, bless your lordship. I place my apology.
No apology required. You read whatever is there. Why are you trying to twist the orders? Yes. Yes.
Yeah, the respondents are supposed to get instructions.
Lordship, I have received the instruction, Lordship.
The CISF, what matter?
Lordship, we have been asked to obtain instruction regarding the issuance of the EWS certificate, Lordship.
Okay.
So we have the instruction, Lordship. EWS was issued for the year 22-23 and 24-25. There is no EWS for 23-24. Our instruction.
So what is the effect of that? It did not apply. File your affidavit.
Lordship.
Let him get an opportunity to
Lordship.
rebut if
Lordship.
he wants to. The State Council submits that the instructions are complete. She would like to bring forward by the union is also filing an affidavit. Yes.
We have rejected.
The
Page 50.
the LLC also submits it, like to be also like to file an affidavit. 3 weeks time.
Lordship.
The date may be.
Let them file their affidavit. What is the point in fixing a date? You may like to file a rejoinder.
Otherwise also the expert here also. They are supposed to dispose of the representative. Till they have not assigned the region. Why my name is not in the final mail?
No, like 3 weeks, 22nd of May,
Lordship.
based on 22nd of
Of
May. You may take back the instructions.
Lordship. Lordship, in this matter, we have received the record. But one thing is that, Lordship, we also require to bring the entire stand of the respondents to an affidavit, Lordship. So we may kindly be allowed time for that, Lord.
Not as per order 7-1, madam. Already an order. Has the affidavit on or before 13th of March. Excuse me. Dismiss.
You're praying for parity of
Yes, my lord.
punishment.
Yes, my lord. Other accused matter who was in the FIR, he has been registered as the accused. Given down, my lord. I have been dismissed.
Where is the inquiry report?
Sir, they have not furnished the inquiry report.
You not furnish.
No, my lord.
How did you file the appeal?
On the basis of the document number, my lord, at page number 60. Even this was not issued to me. I filed an RTI, my lord. RTI was refused. At page number 60 is the order of dismissal.
After no inquiry report furnished. What do your record say?
Kindly come to page number 61.
Lordship, kindly take it after some time, Lord.
Go to the record soon.
Lordship,
The inquiry report is
After
furnished.
10, 15 minutes.
Yes, Dr. Saram. We have forgotten everything. We have forgotten everything. Sir. Refresh our memories.
Issue was that,
148 notice the reasons they made a.
this was that the amount which I received from a particular person on account of the same. Now, they say that this was not genuine. But the distance, company filed their income tax returns, and in the income tax returns, the amount was shown to have been must to me. So the genuineness, the genuineness, and the existence of the company were proved. Now they have come up with an explanation that the said company received the money from these players who were not genuine, and thereby the amount which was given to me that has not been proved. As in also the way of the SSC to prove the genuineness, the legitimateness, and existence of the company from whom the amount was received. The amount from whom, where the amount was received by the said company, doesn't fall within the duty cast of the SSC to prove. It is not possible at all. Proof that where from the said company comes when they display the amount. Now on that note,
What reasons were furnished?
got the regions. Page 85. Page 87. Last third paragraph in the middle. Nothing but furnished to establish the genuineness of the transaction. The credited of the actual existence of the Babycall Trading Limited so and so, and from the furnished ledger of the party noted that the total value of the transaction for the financial year was 30 lakhs. I have therefore reason to believe that the amount of 30 lakhs in this case has been issued assessment, escaped assessment with the meaning of so and so. Now, the state company is very much in existence. So the company is a registered company. Now the 30 lakhs was to the banking transactions. The amount was reflected in the bank account in the return of the said company. How it can be said that the existence of the company, creditworthiness and genuineness in the transaction has not been proved.
No, but for what purpose you receive the amount?
Share capital, no?
Share capital.
By law.
You furnish the particulars of the application and the deposit of relating to share capital.
That is the balance sheet, he received that amount is by share capital, the balance sheet of that person also is shown that the amount is by shares, for shares. In the last see, the baby bonds account below it is 119.
119.
My lord. This is the account of baby bond. And also see page 121. Serial number. Last below from 8 or 10. Trans India Developers Limited. 30 lakhs.
119.
121 below. 8 to 10 from bottom below.
Yes, Trans India.
Developers Limited 30 lakhs. This is the books of account of the
Investor.
investor. And the amount was given by bank, this is the bank. Also, page 71. Page 70 below first.
$71.
70 below.
70.
The last one below. Maybe corn and so and so investor 20 lakhs. The next page below. Take 3 or 4 times from bottom, maybe from 10 lakhs.
On different dates.
2 different dates. My account also page 72 you will also see.
See,
This is the last but 4 line below 20 lakhs. And then next page below again 10 lakhs. The account of baby corn below at page 74. 5 books of account. It's 30 lakhs of baby corn.
yes.
So that the cannot be said that the petitioner had not proved the existence, creditworthiness, and the genuineness of the transaction. Once the creditworthiness, genuineness of the transaction has been proved, how the assistant officer can say that the genuineness and the creditworthiness, the existence of the company has not been proved. That will not reflect before the mediation. that, the duty cast upon the assessee to prove the genuineness of the conviction entered into by the assessee with the person concerned, and it is not the duty to prove the creditworthiness of the subcreditors. One judgment below I may place before your feet. The judgment that you before the
So we have this.
my lord. At page 6, my lord, para 17. Person may have funds from any source, and an assessee on such information received may take loan from such a person. It is not the business of the assessee to find out whether the source of the source from which the creditor has agreed to advance the amount were genuine or not. If the creditor has, by any undisclosed source, a particular amount of money in bank, there is no limitation under the law on the part of the assessee to obtain such amount of money and part thereof from the creditor by way of check or form of loan. In such cases, if the creditor fails to satisfy how he has actually received the said amount and happen to keep the same in the bank, the same amount cannot be treated to the income of the assessee from undisclosed sources.
Yes.
The return to believe shall formed by the have no nexus. The reasons have no nexus with the belief formed by the that the income has escaped assessment. Think of period of income accepted.
Reported, my lord, and it was
Which company?
against the Babylon, my lord, from which
Investor.
investor lordship. So we lordship may see our additional affidavit lordship. We have filed. We have annexed the details of that Babylon company. So it starts from, my lord, page 155. Then page 9, my lord, annexure A. That is the letter, my lord. It was issued by, my lord, Deputy Director of Income Tax Investigation from Kolkata, my lord, making the assessing of their lordship. Later dated, my lord, 27/2/2019. Details of enquiries made. The matter has been investigated. It is seen that name of Babylon Trading and Investment Private Limited appears in the department database as Shell and the is controlled by entry operator Gopal Banka and Colonel Nangalia. Amit Kumar Chaudhary was one of the dummy director of this company and has admitted in statement recorded under section 131 Act that he has acted as only dummy director for the company controlled by and is for facilitating exploitation entries to beneficiary companies. He had submitted the list of such companies during his statement, wherein name of Babylon Trading and Investment Private Limited also appears. Therefore, your lordship may see the name of the petitioner company, that is at page lordship serial number 133, internal page number 14. That affidavit. Serial number 133, Trans India Developers. So accordingly, my lord, this intimation was circulated to all the jurisdictional assessing officers who made an inquiry, my lord, and checked them, my lord, the transaction. At page 15, my lord, the recommendations to AO. The above information along with the details of the documents collected during this inquiry are passed all jurisdictional assessing officers of all the above mentioned assessees found to be beneficiaries with prior approval of Principal Director of Investigation, Kolkata, for necessary taking action at your end. AOs of all beneficiaries are advised to further make inquiry under section 2 as per the latest SOP issued by CCTV to ascertain the nature of transaction and other details as required on account of which funds received by them, including bank account of subject persons under inquiry after airing the funds through various intermediaries as shown in the funds flow diagram, and if such transaction is found to be unexplained, the fund used in the transaction should be brought to tax after taking necessary action under the Income Tax Act. The AOs of all beneficiaries are also advised to coordinate with each other and also with the AO of subject entity under inquiry. So and so, in order to collect evidence and proper taxation undisclosed income of these beneficiaries that is to account for subject under inquiry. The facts mentioned in this letter are indicative and not exhaustive. The details efforts need to be made during the course of assessment and ascertain actual quantum of concealment and take appropriate action as per the policy. So, this information was passed over to the jurisdiction assessing authority. Thereafter, we issued a notice, seeking certain documents was furnished. And after going through the same, this notice was issued. Now, your lordship will see the return which they have filed, page notice 61. They have mentioned the details of share capital. Page 61, note 2, share capital. For a share capital, 17 lakhs equity shares of ₹10 each. These figures were mentioned. Thereafter, shareholders holding 5% or more of the aggregate shares. So, these were reflected. However, the name of the company Babylon is not present. That is not reflected in their this figure. So, this is a case where regular assessment was not done under section 143. And therefore, it needs to be verified. Since there was a clear and specific information we received from the investigation team from Kolkata that the particular company Babylon, their entire transaction is found to be bogus, and they are non-existent companies, only existed on paper. So therefore, this notice was issued. And in fact, when there is
What defect do you find in the returns which were filed, balance? Returns which are
that has to be examined, because no assessment was completed, in the present case.
No, after issuance of the notice, did they file the returns again?
Not.
After the notice, you filed it.
They have filed.
What defects do you notice?
What is
the conclusion?
Yes, the reply to the objections, it is categorically mentioned at the Lordship may see annexure 13, page 91.
No, what we want to know is 147, 148 is not automatic.
Well,
You have to have some finding that
Lordship.
The assessments will have to be reopened.
Lordship. That finding is there, that page 91. Lordship. That is the reply to objection in respect of reasons recorded under section 140 of the Income Tax Act. Your objection to reasons recorded under section so as uploaded on so is noted, your attention is drawn to para 2 of the reasons recorded under section so of the Act, wherein the assessing officer has elaborately recorded a summary of the investigation made by the DDIT investigation Kolkata in respect of the pattern of transactions in account number so maintained by Mrs. Babylon Trading and Investment Private Limited, which is akin to the pattern of transaction typical and
where is the AO's order or communication which is referred here, page 91?
Lordship, the reasons recorded is Lordship at page 85, my lord, annexure 11. Property portion starts at page 86. Para 2. Disseminating of information received from Deputy Director of Income Tax Investigation Kolkata in the case of Friends in the Developers Limited in relation to inquiry in the case of Mrs. Babylon Trading so Kolkata. On examination of bank account number so it is observed that bank account is credited with transfers of RTGS which were directly credited to the beneficiary concerns or layered through the bank accounts of shell paper companies and finally transferred to the bank accounts of the beneficiary concerns. The intermediate companies, as mentioned in the database of shell paper companies, have provided accommodation entries in the form of bogus share capital, share premium, fee arranged bogus LTVS, STCL, and unsecured loan, etc., to various beneficiaries parties. At serial numbers 133 Trans India, in lieu of commission in cash and controlled and managed entry operator. It is found from the analysis that the unaccounted income reaches to the desired destination through banking channel in this process. This is common practice of Jama Kharchi companies in Kolkata. These are operators driven transactions which resulted into entry received by the beneficiary companies in the books. For obtaining entries in the books, beneficiary provides cash to operator which is deposited in the individual or dummy proprietorship account followed by transfer of accounts of different concern. On further verification of the transaction, it is found that Brahmaputra DMT Bus Limited so associate company is the beneficiary of having transaction of rupees 25 lakhs made in the financial year 11-12, assessment year 12-13. From the above, it is clear that during the various
this is the only reason. Para 4.
lordship.
It's not relating to me.
Huh?
But both the TMT is not right.
That has been clarified, my lord, later.
But in the details it mentioned but it's not there.
That's what we are about to ask. Page 86 is a reference to some other company.
Other company.
But that has been clarified, lordship, at page, my lord, page 91, my lord. That in the reply, my lord. Reply
So,
to their
even in the reasons at page 87, your reasons are only at para 4. Essential reason for reopening is at para 4, isn't it?
lordship, para, yes,
Para 4.
my lord.
So that you have to establish genuineness of the transaction.
My lord.
How will they establish it? What are the means to establish the genuineness?
My lord.
If it is the case that no actual transaction had resulted in a different issue, that is not your case. Because it was done through the bank.
It was through banking channel, lord. However, my lord, in their return also, my lord, at page 61, that has not been reflected. The share capital, my lord, which I put it down, my lord, at page 61.
61.
What? During the relevant financial year, my lord, lordship may see the total share capital, my lord, that was shown. My lord, to ascertain, my lord, these transactions, my lord. So this notice was issued under section 148. My lord, in fact, my lord, when, my lord, there are sufficient materials indicating that the particular transaction are not shown, my lord, in the return of income, my lord, then, my lord, the reasons recorded by the, my lord, assessing authority, if there is sufficient material, then that need not to be interfered, my lord, at the stage of issuance of 148. I'd like to place my lord on judgment of the 1993, AI 1993 SC 390.
Yes.
Para 25 onward. Para 25. From a
Para
combined
25.
what? From a combined review of the judgments of this court, it follows that the income tax officer acquired jurisdiction to reopen assessment under section 147A, section 148 of the Income Tax Act, only if on the basis of specific, reliable and relevant information coming to his possession subsequently, as has reason which he must record, believe that by reasons of omission or failure on the part of the assessee to make a true and disclosure of all material facts necessary for his assessment during the concluded assessment proceedings, any part of his income, profits or gains chargeable to income tax had escaped assessment. He may start reassessment proceeding either because of some fresh facts come to the light which were not previously disclosed, or some information with regard to the facts previously disclosed comes into his possession which stands to expose the untruthfulness of those facts. In such situation, it is not a case of mere change of opinion or the drawing of a different inference from the same facts as were earlier available, but acting of fresh information. Since the belief is that the income tax officer, the sufficiency of reason for forming the belief is not for the court to judge, but it is open to an assessee to establish that there is fact existed, no belief or that belief was not at all a bona fide one, or was based on vague, irrelevant, and non-specific information. That limited extent, the court may look into the conclusion arrived at by the income tax officer and examine whether there was any material available on record from which the requisite belief be formed by the income tax officer, and further whether that material has any relation, connection, or a live link for a formation of such requisite belief. It would be immaterial whether the income tax officer at the time of making the original assessment would or would not have found by further inquiry or investigation whether the transaction was genuine or not. If on the basis of subsequent information, the income tax officer arrived at a conclusion after satisfying the twin condition prescribed in section 147A of the Act, that the assessee had not made a full and disclosure of the material facts at the time of original assessment, and therefore income chargeable to tax has escaped assessment. Chapter para 27. In our opinion, therefore, in the facts of this present case, the income tax officer also has rightly initiated the reassessment proceeding on the basis of subsequent information which was specific, relevant, and reliable, and after recording the reasons for his own belief that the original assessment proceeding, the assessee had not disclosed the material facts and therefore income chargeable to tax escape assessment. So, this assessment was followed, subsequently by the Honorable Gujarat High Court, in 2022, and it was held that, even, the facts were disclosed earlier, that was not, subjected to tax, that cannot be a ground for, interference for under section 148. One more judgment, the court has further said, at this stage of notice, when, there are sufficient material, that may not be interfered.
Therefore, we asked him that this is not a regular assessment.
It's 148,
You have to be very sure that the assessment needs to be reopened.
Not.
So there are parameters prescribed under 147, 148.
Not. In fact, the case, since, in the present case, no regular assessment was made, under 148. Therefore, no verification of his return, that could not be, initiated.
Why regular assessment not made?
Normally, only the cases which were flag marked in the, the computer system, that were
Bangalore assessment.
Not. So, it is not the case that, it's a change of opinion, because, no assessment was made, it is only a deemed assessment. And since, these returns were not verified, earlier, and in fact, as your lordship has, page 1, the share capital, that does not reflect, the share, was purchased by that Babylon company. And, there was specific information from the, DDID Kolkata.
But it was submitted before you subsequently.
Lordship.
What is your finding there?
Lordship, therefore,
It is not a, is there any finding there on the review that these information with regard to shares, etc., is subsequent attempt cover up.
Not, my lord, the
According to them, in the returns file, it was not reflected.
Oh, it was defected earlier return also.
not the
This is what they are pointing out.
No, 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 let me show. But in the earlier returns also it was submitted, the same returns have been submitted again pursuant to the notice in the month of December.
Where were the earlier returns? You pointed out, Mr.
page 61, lord.
61.
Relevant portion page.
It was shown very soon.
Page number?
The original return, my lord, that was, my lord, page 61. The reasons, my lord, that has clearly disclosed, my lord, those are not relevant documents were not furnished, my lord. Page 91, annexure 13. Reply to the objection in respect of reasons recorded under section 1. Just clarified everything. Reply to their objection. Your objection to reasons recorded under section 142 of the So-and-so Act as uploaded on your attention is drawn to para 2 of the reasons recorded of the Act, wherein the AO has elaborately recorded the summary of the investigation made by DDIT Investigation Kolkata in respect of pattern of transaction account of maintained by So-and-so. Para 2 of the reasons began with dissemination of information received from Deputy Director Income Tax to Kolkata, the case of Mr. Transgender Developers in relation to an inquiry in the case of Babylon Trading Investment. The name of Mr. Brahmputra TMT Bar at the last line of para 2 is a typographical error of no legal impact as the information received from DDIT to Kolkata summarized in para 2 of the reasons recorded under indicative and not exhaustive. Your attention is now drawn to para 4 of the reasons where the AO has mentioned the gist of inquiry made by him under section 22 of the Act, draw his own satisfaction on the report received from the DDIT Investigation Kolkata. Third sentence of para 4 reads as, nothing was furnished to establish the genuineness or actual existence of Mrs. Babylon Trading and Investment Private Limited. Now, please refer to the notice under section 133(6) of the Act issued and served on you on so-and-so. Point number 4E of the requisition calls for copy of audit report and balance sheet for the assessment date 12/13 of Mrs. Babylon Trading Investment, and point number 4G calls for copy of share certificates. In your reply, furnished in compliance with the notice so of the Act, if failed to furnish the documents called for so as to satisfy the AO. Hence, in para 5 of the AO recorded, I have therefore reasons to believe that an amount of rupees 30 lakhs in the case has escaped assessment within the meaning of circumstances. So these their certificates were not furnished. Therefore, my lord, the assessing officer has reason to believe that the income has escaped assessment, and accordingly, my lord, the notice on the second month. My lord, since there was specific, reliable, and definite information received from the DDIT Kolkata regarding the transaction, so, my lord, the assessing authority was justified, my lord, in forming his reason to believe, my lord, that the amount has escaped, my lord, assessment. And in fact, my lord, lordship, when, my lord, in a particular transaction, when a particular party, my lord, is found to be bogus and, my lord, existed only in papers, my lord, they involve in, my lord, bogus transaction, then naturally, my lord, the other party, the genuineness of the other party is also. View of that, my lord, my humble submission, the assessing authority was justified, my lord. Also, in view of the Supreme Court judgment, my lord, he has the definite information.
Being doubtful is sufficient to reopen the assessment.
My lord, that was
That
not
way you will
produced,
have doubts against everybody.
No, my lord, we have given sufficient opportunity, my lord, produce the share certificate. That was, my lord, the claim of the assessee that it was on account of, my lord, filling of shares capital. So we requested for submission of share certificate. That was not produced, my lord, and that was the specific, my lord, recording, my lord, by the assessor. Not. That's my humble.
My friend has raised two issues. Six of the information received from the making further investigation. I think further investigation. Whether the further investigation can be done or not, you will also kindly see below the Supreme Court at page 26. Part at page 29.
Yes.
Court income tax office does not set out any reason for coming to the conclusion that it is a fit case for issuance of notice under section 148. The material that he had before him for issuing notice under section 148 what mentioned in the report. In the report, he mainly refers to some communication received from the CIT Bihar and Visa. He does not mention the facts narrated in the communications. All he says that from these communications, it appears that these parties, elect creditors, are name lenders and the transactions are bogus. He has not come to the prima facie conclusion that the transactions he referred to are not genuine transactions. He appears to have only a vague feeling that there may be bogus transaction. Such conclusion does not fulfill the requirement of 16. What the provision requires is that he must be reasons for issuing the. In other words, he must have a prima facie grounds before him for taking action 148. From the report mentions, hence proper investigation regarding these loans is necessary. In other words, his conclusion is that it is a case for investigation so as to the truth of the elect transactions. That is not the same thing as saying that there are regions issuing notice in 148. Before issuing notice in the 148, the income tax officer must have either reasons to believe that the region of the omission of the part necessary to make a return the 148 at 9 or assessment year, income tax officer or to disclose to be and fully for the assessment for a year, income chargeable tax is kept assessment for that year. Or notwithstanding that there has been no omission failure, as mentioned above on the part of the income tax officer has, in consequence of the information provided, reason to believe that the income chargeable to same has escaped assessment for assessment year. Unless the requirement of A and B of substance for fulfilled, the income tax has no jurisdiction to issue. From the report submitted by the income tax officer to the commissioner, it is clear that he could not have reason to believe that the regions of omission and of the part of for the assessment of the accounting year in question, income chargeable tax as assessment. Nor could it be said that a consequence of the information provision the income chargeable tax assessment for that year. We are not satisfied the income tax officer had any material before him to satisfy the requirement of either section of A or 147. Therefore, he could not have issued notice. Now, the solution before lawsuit is that, that on the basis of the certain information received, it is his case to investigate to find out whether it is genuine or not. Because the Supreme Court clearly said that 148 notice cannot be issued for investigating as to whether the transactions are genuine or not. Now, on the same issue, recently the judgment has come from page 16, the 11th part at page 20. Page 20 below. In case, this report was the opinion that apart from the consideration that the reassessment notice is cast in over broad terms, it barely mentions that pursuant to such and serious operations of the third party, some material came to the light, and that yet other third parties were entry operators providing bogus entry in the form of the share capital credit, the conditional. The identity of such bogus creators or bogus entry operators has not been revealed, even though it is known, nor are the exact amount which are reflected in the books of such operators are discussed as reasons to believe. This circumstance is held that the BSC cannot be sustained and they are liable to pass. This on the court also had the occasion examine the issue of the money lenders, where the petitioner claimed to have purchased cow dung from the various other companies, and a such and such seizure operation was carried out in the premises of those suppliers. And those suppliers said that we have not supplied, third party has supplied. Such and seizure operation were carried out in the premises of third party. The third party said that we are not making any supply, but we are simply raising the bills, and in return, we are getting back the cash or the 10% below as a commission. Some of the court came to conclusion that on that basis, it cannot be said that there was any escapement of any income to Lossimacy. This was confirmed by the division bench, and ultimately the matter went to Supreme Court by the department, and the appeal was also dismissed. This is below Eveready Industries at page 40. Page 47, 44. It was found. It was found that whose payments were made to labor parties by so-and-so of the company for rendering services like cow dung supply, labor quarter, repairing, fencing, etc. It was found that all the four above-rated companies did not render any kind of services for which receiving payment. They claimed that they were getting the services rendered through other parties. Simultaneously, survey was carried out in the premises of the following three parties who were supposed to have rendered services on behalf of the government's party. The survey of a common director of the above three companies, namely so-and-so, admitted on oath that no service was rendered by the aforesaid three companies to the nature of supply of cow dung, repairing, labor services, etc., as claimed by the companies, namely so-and-so and so-and-so. Actually, these transactions were merely accommodation entries, and the amount paid through checks were ultimately returned in case after looking through the various bank accounts of the so-and-so. This was the regions to be. Thereafter, this was report at page 52. There are 16. The regions which have been recorded in Instrument 48 by the decision officer issuing notice of the Instrument 48 have been disclosed at paragraph 144 of the additional proposition filed by the behalf of the sport number so and so. From the said regions in paragraph so and so, it appears that the company had made payments amounting to so and so in the financial year so and so relevant to the assessment year so and so for the ending service. But in a survey conducted by investigation in Calcutta, it was revealed that the Williamson Maker Group in company had made huge payments so and so for the ending services like cow dung supply for labor quarters repairing the structure, and the safety company claimed that they were getting services rendered to some other party. But the common director of these three other parties admitted on oath that no services were rendered for the supply of cow dung, labor quarters, etc. as claimed by so and so, and that payment were made by so and so were merely accommodation entries, and the amount paid to check were ultimately returned in cash after putting it through 4 or 5 bank accounts. From the regions recorded by assessing officer edition affidavit position paragraph 4 of the issuing the imping notice, it appears that there is no definite or specific material for information whatsoever to show that no services were actually rendered by the aforesaid two parties to so and so, and the payment of so and so were merely accommodation entries, and that the said payments were ultimately returned in cash to so and so. Looking through the various set down. Moreover, in the regions disclosed in the paragraph showing for the position, the assessing officer has not come to a prime of his conclusion that the said payment totaling rupees so and so were fictitious and not genuine and were not made to the business statements of the system. In the absence of such prime of his conclusion by the officer, the court cannot hold that he had reason to believe that the income of the assessing so and so had escaped assessment. Now, thereafter, the judgment of the apex court has been truthful. Check days before lawsuit has been introduced. After lawsuit page 54. The income tax officer in the aforesaid report on the 47 of the Act has stated it appeared from the communication received from the regions person from whom the SEC had taken loan and name lenders and the transaction bogus. But the Supreme Court held that he had not come to the primary conclusion. The transaction to which he referred to were not genuine transactions, they were not agents of primary ground for him to issue notice of the so and so. The aforesaid decision of the Chukmal so and so was followed by the Supreme Court in the case of Lakhanmal Beval so and so. In the said decision, the first ground mentioned in the report of the income tax officer to the Commission of Income Tax for initiating action of 147 related to so and so, whom was the entry payment of rupees 74 and 8 annas as interest books of account of the said so and so, made a confession that he was doing only in the money lending. The Supreme Court, however, held that there was nothing to show that the confession of so and so related to the loan to the SEC and not to some other, much less the loan which was shown to have been advanced by the SEC. Following this, all those things, this number 4 came to conclusion that the 148 notices were illegal and were accordingly below the notices were set aside. And appeal was preferred over the implement. The appeal was dismissed by the department. The matter was carried to the Supreme Court. The Supreme Court appeal was dismissed. Now, my learned friend has said that this was not disclosed in the earlier return. But what I showed to you, Lordship, that was a part of the original return.
Yes.
And about the existence of the company, because we specifically enclosed there with a document to show that the company is an active company, page 90. Page 90, my lord. See the details of the company, and Lordship may see the just from the bottom, the status of the company active. So the existence of company.
So this is a data of what? Master data of what?
From the company board, the company board, no?
This is
about the company who gave us the credit.
Right.
Because they have said that existence of the company has not been proved. What more, my lord, I can prove? Genuineness of transactions have been proved. And my London friend is saying that they want to further investigate. That is not permissible for the 148. You must come to a conclusion, first of all, that the income escaped assessment. The 148 does not permit that because like 143(2), issue notice and thereafter inquire, and my learned friend says that the regular assessment was not made. Maybe after 1 year, the assessment becomes deemed to be final.
That's all. My lord, the only, my lord, the judgment which was referred to, my lord, that's one Rajkal, my lord. But in that respect, I would like to submit, my lord, that pertains to, my lord, the provisions of section 148 before amendment. Right, in 1989.
After amendment more wide,
My lord, that has been
only
clarified.
reasons required.
My lord, that has been clarified in the, my lord, case of, my lord, Assistant Commissioner versus Rajesh Javeri, that I have para, my lord, 21.
Yes.
That's my answer.
My lord, the 148, the reasons, this 148, the condition is on the same first, the reasons to believe. See, not after the amendment in 2002. Reasons to believe, first of all,
What he says is earlier, prior to amendment, there were two parameters. After amendment, only one.
which amendment, my lord? Let me show. 59 amendment, what are the conditions?
In this judgment block.
Some judgment, you forget about the judgment. You all know about judgment. You show that what was the provision and when the notice was issued.
When was it issued?
Notice was issued on lordship.
This relates to 2012, 12-13.
Notice issued on lordship 29/3/2019.
Let us see the provision.
It was further amended in 2021.
That is different. We are not concerned.
89 to 21, my lord. The provision has been.
We are not concerned with 21.
That's all. But the motion. Mr. Senior standing down. Sir.
Okay.
Parties are permitted to file submissions if any. One. Small one. Small written submission.
Why side that is small one? Written submissions also.
The
Today we
reasons,
have- today I have
reasons, whole face.
Hello?
About 10 reasons. The reasons were given and then
Changed.
there was a change.
And the mention was made when the payment was made. Payment was received and thereafter said that payment was made. My learned friend.
This is also 147, 140.
Yes, 147. My learned friend submitted that he could go to thereafter he filed affidavit, now filing written submission also. Affidavit also been filed and written submission.
All right.
They've already filed the written submission. Okay.
But I'm sorry, Milord. Well, as per my instruction, Milord, the proposal was sent by the director. Milord. There was some error. A resubmission of the proposal has been asked from the director. And the director, Milord, in the second page, Milord, will kindly see. Government has written to the director on 24/3 and director has sent it to the inspector for submission on 21/3. We're awaiting from the inspector. Milord. Will give us
what is required from the inspector?
Well, the proposal along with the checklist, well, the payment what has to be made for SIU. Now, which as regards the supernumerary post is concerned, well, that has already been created. Now, for the finance part, Lordship will give us 2 weeks time.
From the what? The BEO.
From the inspector.
Inspector, the proposal will come to the director.
Well,
director will forward it to the secretary. secretary will forward it to the
The
finance.
Fine.
How everything can be concluded in weeks?
But to our to the part these government we can do it. Then
That-
rest
that is not
then
the
they
issue.
find.
Question is that there is a direction, this is a contempt matter. There is a direction to comply the
Earlier
orders.
occasion, there submitted the instruction
Comply
like that.
the,
Same.
the order is to comply. Or you
No,
file
there
an
were-
appeal, review whatever you want.
Appeal
no,
appeal
no.
already filed, appeal has been dismissed.
Appeal dismissed. Then
Thereafter they
Since last
then
2020.
no application seeking extension of time was filed by any of the respondents. Once an order is passed, comply.
Here, but submitted in 2022 also.
Which order are we referring to?
Pilot.
Page number 13,
Page, yes,
13 order.
13. The event portion is at page 14, page para 8.
So the decision for creation of supernumerary
that has been done.
done. Where is that?
Well,
order?
the last order 6-3 million.
Six.
6-3. 6 per month.
Referring to para 3.
Correct.
What is the direction in the order?
The order was to create
Supernumerary post
and the salary.
and the salary. Now the
Which
salary
has
part
to be
for the salary part.
Creation of supernumerary is complied with.
But for the salary,
Salary, they will proceed. See the
Well,
direction at para,
no, but
para
direction-
8.
Para 9,
eight.
para 9,
No, para 8.
para 8 and 9.
So you read para 8.
Yes, Malad, from the above, what transfer is that the government is not averse to allocating the necessary posts to accommodate the services were regularly selected by the selection committee. So the authority will take necessary steps to supernumerary posts.
So the direction is to take steps for creation of necessary supernumerary, which has been done
If needed,
if needed.
to accommodate the petitioner in these petitions, which exercise shall be undertaken within a period of months from the date of receipt of the certified copy of the service. The petitioner has been regularly serving as laboratory bearer. and
Now, are you accommodated in the supernumerary? No. These posts are created.
post.
They have been appointed in these posts.
they are already working.
They are already working. They are already working.
They are working. So it is only
With regard to the-
benefit of a
The salary part.
Salary part was stopped since 1998.
you were working on a particular date, the salary came to be stopped. Right? You're not getting. Came to the court filed issue the direction that you are working, if required, create the supernumerary post. Now these posts are created. With regard to these posts, are you receiving your salary?
No.
You're not receiving.
No.
They are taking steps. How much time will it? What is what we want to know? Because you are under contempt.
Yes, sir.
So you have to explain to the court what is the process that is now
Movement the
available.
the check the SIU for the checklist for the SIU approval comes from the inspector will forward to the government. And the government will send it to the finance.
Counsel for the Education Department submits that has placed before the court communication from the Director of Secondary Education to submit that reports have been called from the Inspector of School, Valpara, for the checklist necessary for SIU approval. towards accommodating the petitioners in the supernumerary reports which have already been created and for the selling. Submits that the communication was issued on 31/3/6 pays for 2 weeks for the time to update instructions. Matter stands considering the submissions made. Matter stands referred instead of 15th of May. Mr. R. Islamic is the writ petition
For the contempt petition.
for the contempt petition. Council for the Education Department will ensure that the reports or information call from the inspector of school Walpara has been received and contents thereof be placed into the next day.
Great.
Mr. Court.
Much.
My finger is in late and possible for the timing not.
Yes, madam.
Starting, my basic pay scale, incorrect basic pay, I have got returned, 2019, I preferred this application before this court, and 2024, they filed an objection, affidavit. Finally, 2025, for the first time, the question of maintainability is raised because alternative forum is there, we can get. For this reason, Lordship is observation made on 16th of February order, kindly have a look, 16th February order. Then next week, hearing date, take some 16th February.
Sixteen,
16th February 2026.
26.
Yes, my lord.
You could go and file it before the tribunal. Why you want to argue on this matter now? On this ground. There is a statutory form for arbitration. Go and approach it.
That situation,
Unless you say this is a matter which falls within the exceptions.
I know, therefore, within the exception, means regard, I will make my submission first. 7th of May, on hearing date.
Counsel for the petitioner submits that you will address the court on the issues regarding maintainability. It will be listed on 14th May.
Give the obligement. Can it be on 19th of May, not?
Not 19, 20%.
Give the obligement.
Lordship, I have gone through the record, Lordship, but in one Lordship, in one document it is in that OP2, the name of the petitioner is there, Lordship. And that apart, Lordship, something is there, Lordship. Before this issuance of the major punishment, Lordship, I think there was no notice, sir. So Lordship may keep it as part heard, Lordship. On next Thursday, I will appraise Lordship. Lordship may dispose it of without any affidavit, Lordship. Some flaws are there, Lordship, I am admitting.
Start 30. Request made by the State Council. Submits that by the short date. Right, sir. We received the record.
Yes, Lordship, record is there.
Yes, received the record. Respondent. Mr. S.P. Das, it is with you. Cited. Inquiry report. Prior inquiry report. Prior notice. Right, issuance of punishment or dismissal.
Dismissal, Lordship. Most probably this will go for de novo, Lordship.
The petitioner has also raised the issue of parity of punishments.
Not really. Deeply obliged.
Now serving as casual employment. Despite serving for 26 years, my lord, she was not given her pensionary benefit. My lord.
You are claiming pensionary benefit.
Yes.
Any response?
Response has been filed by respondent of my lord, the manager, PIC.
What is, your appointment was temporary.
Temporary. It was continued for 26
So
years.
why did you not raise the issue of regularization at the relevant point in time instead of waiting for you after for 26 years?
He may belong to a poor family. He does not know anything about the law, my lord. A for employment, minimum. Yes.
Then who apprised her about the law after 26 years? How
My
did
lord, when
come
she
to-
was prevented from attending her offices, man, she came, my lord. There is no order of her retirement. Subsequently, after filing of the rate petition, one order has been passed by the
What I
annexed.
heard counsel. Sir, the question now, the petitioner, yes,
Yes, my lord. Chokidar come textile decorator.
Chokidar cum textile decorator. Under
My lord, respondent of DICC.
under the Department of Industries,
General manager,
under
yes.
General Manager, District
NC.
Industrial Center. ANC in Haflong.
Yes.
Subsequently renovated on
On my lord, as per her, my lord, person, 1/2/2018, my lord.
1 to
But in fact, there was no order was
18.
30th of June 2019, a notice was served on her. This order was served on her regarding her termination.
You said 1.
my lord, as per information supplied by the 1/2/18.
1
The attendance
to
has-
2018, which however is disputed by the counsel to the respondent who submits that notice was issued
On 36, 2019.
36, 2019,
Next,
indicating the date of superannuation. Has staked a claim for pension having rendered
and other service bill.
pensionary benefits and other service benefits having rendered services for 26 years. Stop. Submitted that rendered service. So they have been regularized. That would take pensionary benefits. You're relying on any judgments?
My lord, latest Supreme Court judgment, my lord, and promising, my lord.
And there is reference in judgment of the apex court. I'm saying recorded in. Stop. Stop for hearing. Part of the hearing list.
My lord, that's his seniority. By the court. Advertisement. After last advertisement, the petition acquired for
No, first, tell us you are working as what?
as my lord, LD assistant.
LD assistant. In which department?
Yeah,
Which office? Which office?
under General Manager District Commerce Industry Department, Silchar, Kasar.
Now, what is your next post that you are seeking promotion to? Senior assistant.
Senior. Now, my lord, sets of advertisement. Out of past advertisement, fiction are appointed now. Selection, all sorts of selections are
No, appointed where? Which post?
my lord, for LDMI.
LD.
My here. Page. My lord, initial advertisement starts from my lord. Page 29. Page 29. My lord, in purpose of my lord, 6 to 2, and the written result of the past advertisement. My lord, petitioners were selected 48 and 93 at the bottom line. 9. Then my lord, bottom
Serial number 9.
serial number 9, my lord,
Yeah.
District Industry and Commerce Center,
What is your roll number?
48 and 93. Then my lord, the result of
When were you appointed?
appointed my lord on on 29 to 2016. Page 30 is happened.
Yes. Same date.
Same.
Then
Then my lord, the result of then subsequently my lord by the advertisement dated initial advertisement was of my lord 17/1/16 my lord. Subsequent advertisement of 10 to 2016 my lord. Sorry, 9 to 2016 my lord. Advertisement was issued for filling up 2 posts of NTM.
another 2 posts.
My lord,
Another 2 posts.
another 2 posts. Selection process, my lord, written as well as computer test are different, my lord, different dates. But when the selection, the appointment was issued, my lord, on the same day, my lord, selection was published, my lord. 29, lordship, as I have already shown, my lord, 29 to 2016. My lord. Now, my lord,
Where is that?
my lord, page 30 is the, my lord, our selection.
In page number 32 is the result
Result,
of the second advertisement,
my lord.
which according to you, or according to which the private respondent was selected.
Was in my lord.
Huh?
My lord.
Where are the roll numbers?
130 and 108, my lord.
130.
My lord. My lord.
Is 130.
My lord, at serial number 2, my lord. Now, my lord, subsequently, my lord, the impugn order, my lord. Page.
What happened to the gradation list?
Now, my lord, gradation is under challenge in the subsequent item number 14. Type challenge, my lord. My lord, impugn page 38, 39.
839.
39, page number.
What is this?
My lord, this is the
merit cum seniority list. Here, my lord, both the two selection candidates from both the two selection process, my lord, club process. And petitioner are shown below the persons who are selected after their
Where is the name of the petitioner?
petitioner was number 1 appeared at serial number 3 and 4 appears 2 appears at serial number 4.
Is it 1 and 2?
1 and 2 private respondent.
Respondent number?
Number, my lord, and 4.
3 and 4.
My lord. Sorry, 4 and 5.
Okay.
Now, my lord. Yes, sir, my lord. Commissioner issued an order.
No, after declaration, when did you challenge this?
My lord, it was challenged, my lord, in the year 2000.
Huh?
It was never communicated as my lord. After RTI, my lord, it was communicated. Prior to this, I have challenged the decision list, my lord. Final decision which was without considering my objection, my lord. My lord, number, item number 14.
For the state?
Worship, I appear for the Justice Department here. Filed the affidavit. Page number 64. The petition, paragraph number 4. He has stated that even though the advertisements were issued on 2 different dates, and the reason 64. Paragraph number 4. It starts at page number 63. And in paragraph number 4, we have stated that even though the advertisement was issued on 2 separate dates and the written tests were conducted on 2 different dates, but the result was declared on the same day, and all the petitioners as well as the private respondents were inducted into service on the 1st of March. So they were the seniority list which has been prepared and has been prepared on the basis of merit. We draw this particular inference from the rule position, which is we have not annexed the rule position as enunciated in the Assam Ministerial District Establishment Service Rules 1967. But your lordship, we find that rule position at page number 96, wherein the private respondents they have annexed the rule position. More specifically, rule number 9 starts at page number 95. The relevant portion is at page number 96. Second paragraph. Let me just read it out.
5.
Starts at page 95. The relevant portion is at page number 96.
6.
When, however, more than one person are appointed on the same day, the inter-se seniority shall be determined according to the position in the merit list prepared by the Deputy Commissioner, here in this case, the department concerned, as mentioned in the note below clause A of sub-rule 6 of rule 6. Provided further in the case of extend, this is not required, but we are only concerned with that particular portion of page 96, second paragraph. Since all of them have joined on the same date, so their seniority was on the basis of the marks obtained. Now, lordship may then go to page number 116. And 117, wherein the mark sheet of the
petitioners were, as well as the private respondents were annexed in the affidavit, additional affidavit filed by the petitioner themselves. Here, if I may take your lordship, the marks obtained, the final mark sheet for roll number, the petitioner 48 general category and 93 MOBC. Date of written test was 10-2.
Page number?
Page number 116.
This is the typed copy of the advertisement.
106 is the type copy of this.
Okay,
116.
116, that is 26th or 29th of February.
Yes. It is for general information for the candidates appearing in the written, practical, and oral test for the course of junior assistant under DIC Kasar against advertisement dated 17/1/2016 and 9/2016 made by the Commissioner of Industries, that the following candidates have been selected by the concerned selection committee for recruitment. So the result was declared on the same date. And the mark sheet, the next page itself, is the next at page 117, wherein 48 got 81.65 marks.
The
Lordship takes
results were declared on the same day,
same day,
but there were two different advertisements.
two different advertisements, and the written tests and were also conducted on two different dates. That is on 10-2 and 22 for the
The
private.
results were normally required to be declared vis-a-vis the advertisement specific.
But it was declared on one particular date, and they all of them joined on the same day. Since all of them, that is the stand of the department. Since all of them had decided joined on the same day, therefore their merit position in the seniority list were determined on the basis of the marks obtained in the selection. That is the official step. And based on that, your lordship, the mark sheet of both the petitioners as well as the private respondents are annexed at page 117, 118.
There is no dispute with the marks disclosed here.
No, there is no dispute. It's just that I want to show the marks obtained by the private respondents were higher than the petition.
That is evident from the chart.
Yes.
Chart was
Page 38 it is there.
page number 86
86.
or 85. These are the marks.
Yes.
86.
Yes.
These are the marks.
86. 86. This is the merit from seniority list of new appointee with effect from this was issued in the year 2020.
Their appointment orders were on the same date. They joined on the same date.
Same.
They got more marks.
My kindly have the last annexure of my edition affidavit, page 121.
Additional evidence.
My lord, 121.
Affidavit in reply.
Additional affidavit, my lord.
Affidavit filed in which representation?
4876.
4876. Additional affidavit filed by whom?
By the writ petition.
Which date?
Because, my lord, in person of order ticket 11/2/2026. Last, my lord. Advertisement, the mark sheet. Start from 101.
Yes,
And last 121.
121.
Mine. The computation 8/9/2020. Net.
Communication dated
8/9/2020. Reference to the subject cited, I would like to inform you that sons of the petitioner's name, my lord. Junior assistant of your establishment have been raised sufficient for reservation. Resolve the gradation list of junior assistant issued by you as serial number 4. As four numbers of junior assistants were joined on the same day, 1/5, though they were appointed against different advertising. Disregard different dates. Poem number so dated point number 1. Said if two persons appointed on the recommendation of some public service commission, different batches, then persons who were recommended in earlier batch would be considered similar to the persons who were recommended in the later one. In view of the above, you are requested to observe the gradation list of the junior assistant issued by as per aforesaid handbook formula. By the commissioner to the general manager.
were appointed together.
Appointed together, but my thing is that
Was
advertisement.
there any recommendation separately made?
Yes, my lord, for filling up two sets of post in two different selection process. The post came backend first batch of it much more earlier the second batch.
Where have you stated all that?
My lord, evident from the advertisement itself, my lord. So, first advertisement, my lord, you don't. Seventeen 1/2016, my lord. Purpose of that advertisement, my lord, written test was held on 10/2016. Now, my lord, if they club together, my lord, then cut-off mark will how there may be persons who get much more marks than the petitioners here in mind in the subsequent selection process. My lord.
procedure under the rules.
With regard to your
Selection process, appointment process.
not with regard to six is there, but with regard to seniority, 11.1 is the rule position at page 93. And with regards to seniority, starts at page 95, 11.
Where is the select list for the first advertisement?
Select list for the first advertisement. There is no select list for first advertisement. There was a common select list. Common, as I've mentioned at page 118, Your Lordship, the merit list was prepared. Final mark sheet, everything was prepared on the basis of
When was the first advertisement issued?
first advertisement was issued on 17/1/2016.
Page number?
Page number
Page
107.
17/1/16.
16.
Yes.
First advertisement. Then the selection process started on
10/2016 written test.
10/16. Then
24/2 practical and oral. 24/2/2016.
24. Oral.
Oral.
Then
For the second advertisement, the page number 115. The written test was conducted on
no, first, when was the second advertisement?
9/2/16.
9/2/2016.
9/2/16.
Written test 10/2.
Test on
22. And oral test on 26/2/2000.
why two separate advertisements?
Not clear there. Basically, most probably it was based on the when it arose. So the requirement of the department.
Then after their selection, which is why we are trying to find out the rules are, there is nothing in the rules to say how the selection process is to be undertaken. There somewhere.
Page 93, Your Lordship, the stated rule 6.
6 is there,
Yes.
but it only shows the source of
Yes.
selection.
The note itself, at the beginning of each calendar year, the deputy commissioner shall call for application to fill up temporary vacancies of any kind which are likely to occur in the course of the year in their respective establishment. On receipt of application by specified date, a test shall be held and a list of all candidates suitable for appointment to the post of NTA shall be prepared in order of merit by the deputy commissioner. The list shall remain valid for 1 year unless it is exhausted earlier, and one such list shall be prepared every year. One list.
One list, but
The deputy commissioner shall make all appointments during the year from such a select list. The syllabus for such tests shall as specified in the schedule 1.
And whether the department has their own
what rules?
pilot scheme. Assam Industry Service. Fine.
Which post? They're meant for which post? Posts are identified here in rule 3. Doesn't include upper division, lower division.
Part one includes the additional director of industries, joint director. Class two is for superintendent of industries, assistant manager, district. Some include
Why two advertisements were issued? Any particular reason? Contemplate issuance of one advertisement.
definitely. Why two advertisements?
Yes, respondents, private respondent, what do you have to say?
I have been item number 15 for respondent number 4 and 5. Lordship, the facts are undisputed. There were two advertisements.
According to you, appeared for the second advertisement.
Yes, Your Lordship.
Selected.
Yes. Yes, Your Lordship,
One select list.
one select list. Date of appointment is the same. We got appointed, both of us got appointed on 29/2/16. And thereafter, there is a merit cum seniority list, which is on 31st of July 2020. Then there's a provisional seniority list. We call for objections. And then there's a final gradation list. So there is one list that they come out with pursuant to two advertisements. The reason being, Lordship, if your Lordship read the note at page 89. The Assam Ministerial District Establishment Service Rules. At page 91, they cover our post, which is a lower division assistant. Three-six is lower division assistant. And these are again 309 rules. So they will trump any circular or handbook. And Lordship, that note was read out. And the note contemplates one select list. So perhaps there was a vacancy that arose after the first
So
advertisement.
that is what we want to know from the government. Why to select here? Why to advertise? That is the core instruction. That have been there in your affidavit.
The law now is, it doesn't matter. Your seniority is from the date when you're into cadre, not from initiation of the recruitment.
No, his grievance is not there. Grievance is not, or at least that is the case predicted, that he is not aware that there was a subsequent
his case
advertisement.
is, no, his case is that the recruitment process pursuant to which I was recruited was prior in point of time. And it
Yes.
relates to a prior vacancy. Therefore, my seniority must relate to that. So I must count. So their submission is seniority must be counted from either vacancy, when vacancy arises, or when the recruitment process is initiated. In which case they are senior to us.
Is that your submission?
That is
Is
very,
that your submission?
My lord, our contention is that, my lord, how both the two selection can be clubbed together.
That is not a submission.
but nothing turns on that. What turns on whether there is a clubbing of selection or not clubbing of selection? If the rules provide,
But there is no dispute that you have joined the services on
There
a
is no
particular date. So your seniority will be counted from that particular date.
is what the law says.
Unless you have filed an RTI. I don't know if you have you raised any questions why two separate advertisements were there?
Why not?
Why
I have challenged that gradation list in the minor because
graduation list will be on the basis of your position in the seniority.
now my lord, even my lord, the seniority list, my lord. 8 is also my lord. There, come over there. Writing is there. Election list.
Is there anything in your possession to show that no, the first advertisement was a separate process which culminated into particular select list where your names were there? And the second advertisement was a separate process which culminated into select list company. However,
one that reflects from my lord, the selection list is my lord, from my selection order. Then computer test, oral, everything was my lord.
maybe on different dates, but
Even
unless you say that the process was, there was a decision taken to have two separate processes.
initial advertisement, March advertisement, we are selected. Starting from my lord advertisement.
You can't say you were selected because your select list is on the same date.
Let my
That
lord,
is what we are asking you, whether there are two separate select
no,
lists.
there is no. My lord, there, the date, my lord, 29 February 2016 is shown. There also, my lord, two dates are there, 29, 26 to 29 February 2016. Okay, may I just read the paragraph?
We'll have to come back.
Yes, sir, yeah.
In respect of item number 31, also this was a part heard matter. You also had heard the matter extensively. For some reason, the registry has not reflected it as a part heard matter. You also had asked my learned friend to produce the records also on the last occasion. But my learned friend was saying he has some difficulty today. He's in the middle of some other part heard matters. May I pray that perhaps the matter may be fixed on some other day at the convenience of the office, on perhaps on 5th of May, subject to notice for final disclosure.
5th May, not possible, it goes to end of May.
Lordship, that would be because the person is they have
We
proposed
don't
that-
have, boards are filled up. So
actually it's for finals. I'm still willing to take a
the
chance.
earliest we can give you is 19th May or 21st May.
Lordship, my learned friend is otherwise a formal party. She's not required in the.
There is a complete from the UPC side. They have letter to us that on effective
Asking for your absence. Be present by all means.
Lordship 19 to 20. I am not available.
Lordship, may I in that case alternatively say that the matter is taken up today at some point of time? Because all the councils are otherwise available, the records are also available, subject to your lordship. If it be taken up after the admission matters and my learned friend is then
We'll try.
after.
Your records are not available.
Records have, I have already received.
Then what is the difficulty?
Records, I have 2 matters in. That's why.
You tell us a date when you don't have matters or less matters.
If it
Lordship.
possible of even fit.
5th is not possible.
Then 7th, that perhaps question lordship for 7th of
There are 28 hearing matters on 7th.
lordship because it's already a part code matter.
We don't know how many partners will appear on 28, on 7th, but we can have it on 7th.
Let us try and.
All
take a
right.
chance. I'll be
7th.
deeply obliged to you.
On joint request, matter stands referred to state on 7th of May, which is
31 lordships.
31.
Lordship means the regime.
7th of May, there could be some difficulties. You can have it on 12th or 14th.
I'm okay for 14th of May also.
14th?
14th.
All right,
Then
14th May.
14th. Lordship, the interim order may kindly be
Interim
extended
order, if any,
and the registry
continue.
directed to list it as a part heard matter.
You
That-
mentioned
that-
it.
That order is already there on record. For some reason, that order was never uploaded on the website. Lordship, kindly peruse the file. The
All right.
matter is already kept as part.
We'll direct the registry to continue.
I'm deeply
Yes.
obliged to that.
Acha.
I repeat. 876. The final mark sheet of the first phase. Page 42. My lord, final mark sheet for the junior assistant of so that's our first phase, man. Petitioner's name is there, serial number 2 and 3. Serial mark
2 and 3 is petitioner.
petition. 81.6.
Petitioner 1 is 2.
2 and 4 is the petition number.
Huh?
Petition number 1 is that serial number 2, man.
Ah,
And 2 is serial number 4.
you said 2 and 3.
No, 1 and 2. Petitioner number 1. Now, my lord, kindly turn the next page. The second page, final mark sheet. Name of respondents appeared as 3 and 4 marks. Now, my lord, going by the marks,
Is that does it also include the name of the petitioner?
yes, ma'am. No, subsequent on petitioner name doesn't appear. Now, my lord, two different selection process, ma'am. Now, my lord, whether it is at all possible, ma'am.
You don't know, it shows the law.
Now, my lord, considering that fact, my lord, one thing, my lord, in this case, petition number 1 obtained 81.65 and petition number 2 obtained 69.25. Now, my lord, page 43, my lord, there are candidates who get more than, my lord, 69.65, my lord. Now, if they club together, my lord, petition number would not have been selected, my lord. Now, my lord, on this issue, my lord, I was informed my client, my lord, to club the different select process, my lord.
In the second list, there is no one in 69. There is one on 70.
My lord, more
One-
than 79,
70, 78, 79.
my lord. Now, my lord, on this issue, my lord, I was informed by my client, my lord, club to different selection process, well from the selection process.
On what basis?
My lord, as my lord evident from the
You
page,
produce the records, government, you produce the records. Let us see what prompted selection process to be undertaken. And that too in such succession. But we want to know why. Under your own rules, you have to advertise all vacancies available at the beginning of the year. First advertisement you issue on 17/1. Second advertisement you issue less than a month later. Any particular reason? Any authority you want to rely on?
my lord, I was, my lord, my lord, right, what I and the
Is there any notification that separate advertisements, separate selection process, the appointment orders are to be separately issued? The rules are silent.
my lord, on this issue, my lord, the client trying to find out.
Clients have told you, but have you made an attempt to find out
they-
under what provision the permission is required? Or approval is required?
Now, they inform me, my lord, club to different selection process, my lord, approval from the selection committee.
Huh.
And let them produce record also, my lord, record will make clear everything, my lord. The selection list, the seniority list, my lord,
Record will be produced for perusal of the court,
Fine.
not for your perusal.
Fine.
But is there anything to submit that? You see, your appointments are made on the same day,
Same.
joined on the same day.
My lord, 42 and 43 clearly reflects that, my lord.
Selection process.
When, my lord, clubbing together may not, not considering the fact that, my lord, there are the candidates who got much more marks than petition number 2, my subsequent selection. Finally,
They were not appointed.
they were not appointed.
That's what I think.
The petitioners and the respondents belong to which category?
General, OBC and SP. And one OBC.
Then
And
Fine, right.
produce the records. Let us understand why you have initiated two process. What is the rationale leading to all this confusion? Mr. Nair, anything to submit?
the other petition submissions.
Let us have, is there any rule, is there any notification to show that yes, it can be done or it was
Gotcha.
required to be done?
Doctor, may I just take a moment? Their pleaded case is that their recruitment process began prior in time, therefore you should not have clubbed. Independent of that argument, clubbing doesn't take you anywhere. So until Parmar's case, seniority goes back to date of vacancy or date of recruitment. In which case, if the authority has clubbed, then that would be wrong. Because the law was that, you go back to when the vacancy arose and pursuant to which initiation of recruitment happened. So it doesn't matter when you got appointed. Your seniority will be, then he is senior to me. First of all, the rules don't contemplate that. Even if Parmar was there, I could have argued that the rules contemplate a merit list, and that is what they did. There was one list merit.
Then came the Manipur case.
That came exactly. And thereafter there's the Meghraj case, which basically overruled Parmar and says the date of appointment is when
You claim your seniority.
you claim your seniority.
You can't claim it
That's right.
prior to
That's
being
right.
born into
So
service.
just clubbing on its own doesn't take him anywhere. Clubbing is wrong if you have
The
to go back.
question is, that is what we want to find
Yes,
out,
yes,
why you
yes,
have had two
yes,
different,
Yes.
your argument that it is for separate categories also does not justify when the subsequent list contains persons belonging to other categories. Yes.
Then he's challenging the merit list.
No, but his argument is in the subsequent select list, there are persons securing higher marks. But in the appointment order, for some reason, those persons' names are not there. Have they not joined or they have joined? What has happened?
Lordship, that is an independent argument of clubbing, because then if then he's relying only on the second. Then he's not talking about clubbing. He's also not clear of what he's arguing, Your Lordship. Or I fail to understand.
This argument is not supported by any record.
So, therefore, we want to see from the government's record what is the reason for that. That's all. And he says that there is some approval necessary from the selection committee or selection board. Under what provision is there?
The evidence filed by the department says APSC was never done.
It was not required to be consulted.
Produce the reports pertaining to the selection. When can you do that?
Pathard?
Third council for parties. That's by clubbing separate selection process by publishing one select list. Commissioners, seniority. Commissioner seniority is effective. Commissioners, they were selected pursuant to an earlier process for selection by an advertisement dated conducted by more than 17/1/2016, whereas the respondents had applied and were selected pursuant to second advertisement dated 9/2016. So both selection process being conducted separately, there could not have been a combined select list issued whereby the private respondents were shown to be above the regulation, thereby affecting seniority position of the reputation. Stop. Not as to why separate selection process were undertaken by the department, that too. Available in Studio Window 1976 or 67? 67. Also does not go in library. Stop. Therefore, the court that Department of Records would be the reason why the department proceeded to undertake two separate selection processes by separate advertisements. So, Mr. D. Bora, State Council, submits that the records will have to be called for rephrase for 3 weeks' time. Mr. J. Laskar for the petitioner. Ms. G. Goswami for respondent.
4 and 5.
4 and 5 in WPC.
4876.
4876. And Mr. D. Nayan for respondents.
3 and 4.
3 and 4 in WPC 2357 of 2022. Let the matter be listed again on 21st. 26th May. Matter has been heard at some length, therefore should be treated to be a partner matter.
Challenging the eviction order, as well as for modification of the earlier order, so this eviction process has been going. The petition rule also is that the leaseholder under the private respondent's Miller, and on 2023 Miller,
What are you claiming?
I am challenging basically eviction order.
It was heard in part. Was it heard earlier?
Last time that I was.
Why is it shown part heard?
As per the last order, order prior to the last order, it was said, since there is an order passed by your lordship, which is a part of in the earlier round of litigation.
What order?
Lordship,
If
at page, if lordship is taking the first item, it's at page 32. page 34.
So the disposal of matter.
It was a disposal of matter wherein it was directed by this honorable court to the DC. The directions are given at page 37.
Now you are challenging the subsequent orders passed by the DC.
I'm not challenging the order. I'm challenging the order of eviction as well as modification of this particular order. This particular order. That's why our complaint bench has-
Modification of the order dated 10/6/25.
Yes, yes.
24.
Yeah, this order. Yes. Yes. Because in this,
Modification by filing a separate writ petition.
that this fact has been discovered after filing their reply. That's why.
Then you file a review. Why are you filing a writ petition for modification?
Not eviction order was not already passed. That's why I'm that making that similar claim.
You want some modification in the order at page 34. That writ petition is disposed of.
Yes.
You are seeking a modification. Then you have to file a application for review or modification. Why when you file a writ petition?
Is that eviction order? That's why I'm telling the eviction order also.
I have a party not for any modification. Whatever the private respondent 5, 6, and 7, but if they filed a representation before the deputy commissioner for stating that some portion of a land therefore corporation has been encroached. That being by not disposing of that reputation, they filed a earlier state of reputation before the honorable court. And this court lordship, the relevant portion is that lordship will find is the best for the order. Directing the respondent to dispose of consider the representation filed by the private respondent number 5 and 6, 5, 6, and 7. And if required, a personal hearing would be conducted on the said land, whether the land may be enclosed or not. And thereafter, whatever the deputy commissioner directed the circle officer to conduct the hearing, and in pursuance to hearing lordships, the eviction notice was issued to the petitioner, and against which lordship we have filed this instant petition before you.
No, pursuant to the order passed on page 34.
Yes, sir.
There was the hearing conducted by the DC.
Yes, sir.
What happened after that?
The eviction notice was issued by the circle officer to the petitioner, stating that they failed to substantiate their claim over the land. Initially, the land.
Then what you challenged that notice in the
Yes,
present
yes,
proceeding.
yes. From the lordship,
You
whatever
should
the
go before
land,
the appropriate bench.
land originally lordship is reserved for the Buchi Kopostari. It is
Whatever
not
it
a
is,
open land.
this is the bench 5 matter.
Yes, lordship.
You should go before the bench 5.
Since the issue is same, that's why both matters are
Oh,
passed
issue
together.
may be same, but
No,
these benches are rostered by the chief
Yes, sir,
justice.
there is a.
I'm saying earlier that separate issue.
Ah.
I am seeking modification of the order against eviction. They are challenging the eviction.
You are seeking modification.
Separate
You are seeking modification.
as well as
Since we are directing the matter to be placed before the appropriate bench, we are not saying anything, but seeking modification by writ petition, I have to be apprised under what law?
Because there is an order passed by Honorable Justice Lordship. The state bench lordship directed to the matter before your lordship.
Which can be done.
Yes.
Listing is the private prerogative of the chief justice. But counsel for parties, this appears to be a matter, subject matter covered under civil bench 5. Matter is listed pursuant to an order dated 6/3/26 passed by court of bench. Standing in this court, subject matter present petition is covered by subjects under civil bench 5. Therefore, registry to make necessary verification and place the matter before the appropriate benches. Take steps to place the matter before appropriate bench.
But
Holding the rostered with the civil bench 5 members.
Interim order passes.
No, nothing. We are not passing any orders.
But interim, there is a interim order.
Let it continue. Has it been vacated?
No.
Then
What is the seniority difficulty, Lordship, today? When we fix it on 28, Lordship.
what difficulty?
Lordship is engaging another court, Lordship.
That is not a ground for adjournment, madam.
Lordship,
Why
then
do you
Lordship,
keep repeating these adjournments?
pass over for the timing, Lordship.
What is your problem? Why can't you prepare the brief and assist the court? What is your difficulty? You are appearing before the court to make a mention.
Senior,
Your senior is not available. You are there. He has instructed you. Has he instructed you not to study the brief?
No.
Then why can't that effort be made by you instead of repeatedly saying that so and so is on some other court, some other legs, on legs in some other court? You don't have the brief. You take the brief of the court and study it. You study it, we'll take it up after a while. At the end of the list. Yes.
As per the last order, we were directed to bring,
Hmm.
as per the last order, we were directed to bring records, but Lordship, we need some 4 weeks more time to bring the records pertaining to all the districts.
So thus, yes, what is to be done?
Records will be necessary. 4 weeks maybe. So, after 2 weeks, they can find out from different district whether the verification has been carried. That's what precisely the order was passed by this court. 13/3/2026. The court want to look into it, that the verification was carried out on. Can produce after 2 weeks because your 13/3/2026 was the order that was been passed by this court.
Well, we'll give them 3 weeks.
Yes,
Mr. D. Das in the council assisted by Mr. P. Hearing board,
water resource.
PHED,
Water,
water resources. Submits, renews a prayer for further time to bring the relevant reports. Considering the prayer made, that the matter be listed again on 20 May 0. List accordingly.
If it is so difficulty after 2026,
22nd,
26,
lunch.
simply of.
none appear for the petitioner on call. P. Bora, Council Voting Health Department, and Mr. ABT of Holy. It's the matter after a week. Yes.
Lordship, here the issue is regarding non-payment of weekly pension as well as the professional pension. So my husband, my lord, who was working as a SDMNHO at School Health Jorhat, he died on 29/7/2021. And my lord, my the date of my lord superannuation was on my lord 31/8/2023. Service period he died. Thereafter, I prayed for my lord. I am the legally married wife, and I have enclosed my marriage certificate also, my lord, which was issued by competent authority of Register Muslim Marriage and Divorce. That your lordship will find at page number 16. My lord, as I have not been, my lord, getting in instruction and anything, my lord, as I have been come to know that no progress of family pension. Therefore, my lord, I have filed this instant invitation, my lord. And
Is there an issue of more than one wife?
I'm the only wife, but here, my lord, they are the contention of the, my lord, respondent, my lord. They have filed their affidavit, my lord. Their contention is that, my lord, I have not submitted next of kin certificate. Is number one, my lord. And regarding that, my lord, what had happened, my lord? We were, my lord, issueless. And immediately after the death of my husband, my lord, my other legal heir, my husband's brothers and his sons and all, they have obtained an NOK. Then, my lord, I made the complaint before the authority, and thereafter, my lord, that NOK was cancelled, and that was not issued my name thereafter. So, my lord, my
You
lord,
have applied for a fresh NOP. Have you applied?
my lord, we have prayed. We have prayed for issuance of NOP.
No, before issuance, have you applied before the authority is concerned? You must apply first. You have prayed for cancellation of an NOK obtained by the brothers. That was cancelled. Now, pursuant to that, have you applied before the authority that you are the next of kin?
My lord, here, my lord, when the NOK was reverted, my lord, it was ordered, my lord, NOK reverted in case of legal heirs of
Page number?
No, my lord, I have time. But my lord, here my contention is that, my lord, as I am a legally married wife, then, my lord, here is not a condition precedent that, my lord, NOK need to be submitted. Because
Is your name there in the pension papers? I mean, the service book, nominee?
my lord, in the, that is not there.
Then
That is not there. Because what had happened, my lord?
is there a marriage certificate?
Yes, marriage certificate is there.
So there has to be a finding by competent forum.
Yes.
No, but my lord, it's a valid document, my lord.
It is a valid document. What we are asking you, what prevents you from here asking for an NOK? Whether it is mandatory, not mandatory, how is it material? You have to go and apply to the authorities asking for an NOK. What stops you from doing it? Instead of arguing whether it is necessary, not necessary.
When, my lord, the NOK was, my lord, that alia NOK was reverted, then, my lord, an order was there by SDO. Civil office is not a competent court to decide the matter of legal heir in this case to issue NOK certificate, and the concerned parties may reach to the competent court having proper jurisdiction for the same. But, my lord, the competent authority is the, my lord,
Your
district administration.
pleadings are complete here.
Pleadings are complete.
Pleadings
Yes,
completed.
yes.
So it heard Leonard Townsend for part one, call for reports. That will be listed for hearing in part two. Mr. C. Borwa, counsel for the accountant general. It is for you to decide. If you want to file, you file it. No date, part two hearing list will come. We have issued the rule for the reports. when it is listed, you are entitled to make a mention for upgrading.
So under section 11 of Arbitration Act for appointment of the arbitrator. Okay, the relevant, the clauses are in the page 27. And lordship can go to clause 38. The arbitration is there. Clause number 42. In arbitration clause, lordship. After that, here we got, we are given a mandatory notice. That is in page number 72. Page number 72. Notice is also there. And the issue here, against the execution lordship, my learned friend has filed an objection. The matter of non-arbitration. The matter is non-arbitration. Lordship kindly go through their objection purpose.
No, first let us understand what is the agreement for.
Yes. Is that I am one of the agreement is in page number lordship 27 lordship. This is the agreement. Also, I am one of the partner of the, this is a unregistered partnership form. So I
You
am
said
also
registered.
unregistered.
No, the agreement says registered.
No, agreement is there, but as per partnership, it is not registered.
What is the name of the firm?
Akash Ganga.
The page number 27 said Akash Ganga is a registered firm.
Page number 27. No, lordship registered means there is a two things lordship. As per partnership act is not registered. Because
From the agreement, it says a registered firm. Registered means registered under partnership act.
This registration is the sub-register. The deed is registered in the sub-register. Not the partnership is not registered
Partnership
in the, under the partnership.
so in that case, we are called the unregistered.
The language says registered firm. When you see language, Akash Ganga Construction, registered firm. Registered under what?
Registered in the register office.
Anyway, so
Anyway, lordship, this is what lordship. There is a dispute, lordship. Here, lordship, the dispute is very clearly written in the page number 70 when notice is being served. 72, lordship. Finally, go to page number 72. Everything is there in the
notice. Yes. Tell us what is the dispute?
The dispute is that lordship, there is an agreement. We made an agreement with the this with the respondent. This is 60 Associates India, that is Bill Sagola, for construction of a plot of land in our plot of land. That is, we are having around 10 bighas of land where we are giving them a loan. We have that will become a joint owner. Thereafter, what they did before handing over all the position lordship, they made a road over there and constructed a building. Here, this agreement is for a part of land which is 10 bighas of land. 10 bighas of land. Where there is a road, they made a road and constructed another plot of land, 3 bighas of land, where they have constructed a building. They have procured a permission and they have constructed a building showing this part of land. Showing our land, this land, showing our land where we have not authorized. Showing our land.
The subsequent construction is In which plot of land?
Different
plot.
Different,
Different plot of.
different plot. But the road is shown in our plot. So here lordship, I'm not on.
So approach to that plot of land
Yes,
is shown through your plot of land.
yes, lordship, that is our concern. That is for that reason, we have made a notice to them. We have filed section 9 petition also, appeal is pending. But their concern is that lordship, in this case, their concern is that their matter is not arbitrable. So that part is being decided by the Supreme Court also in the judgment.
You know, which part is not arbitrable?
They are saying that this as because there is a clause there in their objection they have stated. I can read lordship. Their objection. Only that part the matter is lingering lordship. That matter is being decided by the Supreme Court. Their objection in the earlier part, there is a page number 14. It was not at that time. It was not single number.
The objection is that
objection.
There's no serial page number at that point of time.
objection on behalf of respondent 1 to 3.
1 to 3.
All right. Then
Filed on 15/3/2020.
paragraph.
Paragraph also page number 14 also.
14.
14, 1 4. They are on the only one point lordship. They are in the whole objection lordship. They are saying that in the whole objection petition, the issue of arbitrability of the matter has been already raised before the Honorable Gauhati High Court. That is in the appeal lordship. They are saying that the matter is not arbitrable lordship. Others are not there lordship. That fact lordship. On this admission lordship that they is not arbitrable, I am relying on the judgment.
What is the issue? Judgments will come later, but tell us what is that issue which they are raising objection that is not arbitrable, or it is outside the purview of the agreement.
Not that arbitrable. Whether I'm not onto that whether matter is arbitrable or not arbitrable. Lordship, as per this judgment, lordship, arbitrable or non-arbitrable has to be decided by the tribunal. Lordship.
So what is the use of 11.6?
11.6 has to forward this judgment.
So you are saying that the judgment has said 11.6 is the post office. That you file a petition, appoint an arbitrator, everything else will be decided.
That's a kind of with this judgment. The Office of the Alternative Architecture Lordship. Here, Lordship, I'm saying from the para 2 Lordship, the appeal impugns the judgment and order of the High Court of the Delhi and New Delhi, dated so and so, whereby the appointing arbitral tribunal in excess of power under section 11 of the excess High Court excluded the petition. Certain claims as stated in paragraph 14 so and so, the claim petition by the holding them to be non-arbitrable accepted matters in view of the clauses so and so. In a nutshell, I'm reading the whole judgment, Lordship. In a nutshell, the case of the appellant inter that while exercising power under section 11 of the 1996 Act, the court has to only examine whether arbitration agreement exists or not. And if it exists, an arbitrator is to be appointed who thereafter would decide whether the claims fall within the accepted category or not. It is the way that the maintain order to extend the exclude certain claims be set aside by leaving it open to the parties to raise all these before the arbitration panel. Par contra, the learned counsel would have responded and submitted that the High Court is empowered to non-arbitrable claims in the light of the decision of the court in so and so. This judgment of. We have considered rival submission and have perused the materials on record. The short question falls in our further consideration is whether, while exercising power under section 11 of the 1996 Act, the court has to confine its consideration as to existence of arbitration agreement between the parties. If so, whether it would be permissible while exercising jurisdiction under 11 to hold that some of the claims raised are non-arbitrable or fall within the accepted category. Subsection 6A of section 11, which was inserted by Act 3 of the 2006 with effect from so and so 23/10/2015 makes it clear
that while considering an application under subsection 4 or subsection 5 or subsection 6, the Supreme Court or the High Court, as the case may be, shall, notwithstanding any judgment, decree, or order of any court confined to the examination of the existence of an arbitration agreement. Act 33 of 2019 omitted subsection 6A, but the amended act has not been notified thus far. In consequence, the subsection 6A of the section 11 of 1966 Act remains in the settled form. The statement of the objects and reasons of 2015 amendment with reference to the insertion of 6A in section 11 of the Seniority reads as an application for appointment of an arbitrator shall be disposed of disposed of by High Court or the Supreme Court as the case may be. The endeavor should be made to dispose of matter in this system. Paragraph 10 I am reading. The significance of the use of expression not other issues in the statement of the reasons of 2015 amendment noticed by 7 judgments of this court in the interplay judgment and the Indian Stamp Act, and it was observed. The above extract indicates the Supreme Court or the High Court at the stage of appointment of an arbitrator shall examine the existence of prima facie arbitration agreement and not other issues. These other issues not only pertain to the validity of the arbitration agreement but also include any other issues which are a consequence of unnecessary judicial interference in the arbitration proceedings. Relying on the above observation made by the court in interplay, chief bench judge of this court in SBI General Insurance judgment I have also. The scope of inquiry at the stage of appointment of arbitrator is limited to the scrutiny of prima facie existence of the arbitration agreement, nothing else. For this reason, we find it difficult to hold that observation made in Dictatorial and adopted NTPC that the jurisdiction of the referral court when dealing with the issue of accord and satisfaction under section 11 extends to weeding out ex officio non-arbitrable and privileged dispute would continue to apply despite the subsequent decision in the interplay. As the above decision has been rendered by 3 bench judgment of this court, after considering the 7 bench decision of this court, we are of the view that the respondent cannot profit from certain observations made by 2 bench judges of this court in Imar Supra. In our view, therefore, the High Court fell in error in dissecting the claim of the appellant into parts, one arbitrable and other non-arbitrable.
This is not, this issue is not before the court. The question is not whether the issues are arbitrable or not arbitrable, part of the issue. What they're raising is that there is no dispute as far as the arbitration is concerned.
As far as my understanding is concerned, Lordship, my understanding is that whether arbitrable or non-arbitrable has to be decided by a tribunal.
Arbitrable or not arbitrable presupposes there is a dispute.
No, I am on one.
What are you going to arbitrate?
Lordship.
What is the tribunal required to be set up under 11(6) going to arbitrate?
Lordship, that is my claim, Lordship. That is only in the mind.
What is your claim? That's what we want to understand. Why have you raised this? Why have you issued the section 21 notice?
Lordship, that part I can that part I am saying that Lordship that only.
You are saying that we are not even competent to look into that.
No. I'm due respect, Lordship. I'm not going to that part, Lordship. I am going to that part. Only for the judgment, Lordship, only that part, Lordship. Whether
the judgment is where the High Court decided on certain materials that whether this is arbitrable, that is not arbitrable. That part is referred to arbitration. This part is not referred to arbitration. Supreme Court says you did not do that. Leave it open, send it to arbitration, let them decide.
Yes, sir.
But this is not an authority to say that even if there is no dispute, Section 11 court has no option but to refer it to arbitration.
No, my understanding is that, Lordship, from this judgment, Lordship, whether my question is that Lordship he is admitting my arbitration. He's not denying that from the objection that he is accepting. He's saying that arbitration, the matter is not arbitrable. Their only objection is that
we are asking you, what is the dispute for which you have issued a notice under Section 21?
That's
what is that dispute?
Dispute is that, Lordship, we own a plot of land.
From the parameters, from the agreement which is executed, you show us that this is the dispute.
Lordship, yeah, Lordship, the agreement is on page number 27.
27.
The dispute is a lordship can go to only another part also. In my notice, this is the notice. This is the agreement. The agreement, the second party and the instance of first party having obtained work for development of the para number 18 lordship. Clause number 18. Sorry. Clause number 18 lordship. This is also there, clause number 18. The issue in a nutshell, if I say lordship, without going to the agreement also, I'm referring only that there is a one plot of land, we purchased a plot of land. We had a plot of land around 10 acres lordship, where we allowed them to construct flats lordship. But they do not become the owner because we own the land. We become the joint owners, because while giving the land, we have not given the we are the
You have entered into a development agreement.
yes development
Now,
agreement.
the respondents who are the developers, they develop, they also retain flats.
Yes.
They retain flats. So if they retain flats, then they are also corresponding owners of that proportionate
We are the
amount.
joint owners. We become the joint owner because land is in my name and permission is also in my name in this case. So they are the developers, lordship, but they are the developers, but the permission was in my name. Lordship, that's all. So where as I given them the land to construct the flats, lordship, they become the joint owners as per my understanding. So after that, what had happened, lordship? They constructed it. So there is a we took the permission from the CMD and CMC. We took the permission. The permission is in our name, lordship. So what had happened after that? The building was constructed, but they from our plot of land, from our they sideways they have constructed another plot of land where our road is being used. So I am claiming, lordship, in that part, lordship. So I'm getting the notice, lordship. From that it will be clear. Page number 72. Your firm, I'm referring to their firm. Akash Ganga Construction is entered in deed of agreement having deed number so and so, which is registered with sub-register Assam, where the undersigned is also one of the signatory being partner of the said firm, whereas the said Akash is not registered with the register of society. That the said deed of agreement was signed by the undersigned in representative capacity by being one of the partners of the Messrs. Akash Ganga Construction. That by the agreement dated so and so, it was agreed that the exclusive right of development of a plot of land, that is combined plots of land being so and so, was accorded for construction of a multi-story building. It was specifically accorded for construction of a multi-story building. There is never stated that there is a road to go to another plot of land. The name of Messrs. Akash Ganga Construction is accorded for construction of a multi-story building to construct over a scheduled land stated in the agreement dated so and so. That it was agreed that your firm to raise multi-story building as per GMJ NOC number so and so, dated so and so, as per the agreement dated so and so. So they were agreed and as per the NOC dated, but they have bifurcated, they have diverted the NOC. So this arbitration is required. That in the said agreement dated so and so, it was also agreed between you and your firm and the firm of the undersigned, when I had presented as one of the partner and conceded to carry out construction activity in a adjacent plot of land of some other landowners, and had also devised as to how the benefits accruing in your farm for such construction in the adjoining plots of land, and the details are narrated in clause 18 of the state agreement.
Where is that agreement?
Agreement
31.5.
Page number 27. Actually, after that, this thing, that it is seen that, para number 6 also, that it is seen that since 2019, your firm is carrying out construction in another plot of land property faced from society. Being a plot of land measuring so and so, situated at the revenue village, the district of Kamrup, Assam. And for carrying out such construction, your firm is using the scheduled land of the present agreement dated 31/5/2022 for ingress and ingress of the same is being used without the authority and permission of the undersigned, who has a right over there being partner of the Messrs. Akash Ganga Construction. That such action on your part is clear violation of the terms of the agreement dated so and so, as much as while the agreement dated so and so clearly laid down that scheduled land can only be accessed to construct the adjoining land as described in clause 18 of the agreement. However, you have, by violating the agreement and the intent of the parties, have used the scheduled land to construct a multi-story building over the adjoining plot, which is not the land described in clause 18 of the agreement. Which is not in the clause 18 of the agreement. That your act of violating the terms and the intent of the agreement dated so and so has resulted in nuisance in the scheduled land, and further that you had used the scheduled property without permission against the intent of the agreement dated so and so, and had reaped whose benefits without giving any share to the undersigned, who had represented in the agreement dated so and so, being one of the partner of the Messrs. Akash Ganga Construction. That you many occasions on the undersigned had approached you. In many occasions, the undersigned had approached you. However, you paid no heed and continued to flout the intent of the agreement dated so and so, causing injury in terms of loss of monetary profits, which is illegal and in clear violation of the terms of the agreement. That as you have failed to accede to my verbal as well as written request to resolve the dispute between the undersigned and you others, the undersigned hereby invokes the arbitration clause narrated in clause 42 of the agreement and proposes to appoint as the sole arbitrator to adjudicate upon disputes among us. So that undersigned further said that undersigned had approached the Honorable Court of Additional Judge number 3 with a prayer for interim protection of the section 9 of the arbitration conciliation by filing misapplication number so and so. And the Honorable Court by the order there was pleased to grant the interim protection by passing an order to maintain status quo over the scheduled plot of land. And the agreement then of the agreement dated so and so, by number so and so, and the same was duly communicated to you. So due to the violations of the order dated so and so from your end, the court had enforced its order by passing an order dated so and so.
Now, in terms of clause 18 is the bone of contention, isn't it? Of the agreement. Clause 18, what have you stated? You have permitted
Clause
for
18,
construction.
yes. I have permitted construction of the plot of land which is in my land, not in others.
No. Read clause 18.
Yes, Lord.
It's very clear.
That the second party at the instance of first party had obtained a work for development of adjoining land that is measuring one so and so and the number so and so, not in this plot of land. This is another. Not where they have now constructed, Lordship. This is not that.
Okay.
My contention is that, Lordship, my contention is that, Lordship, they are not constructing in my plot of land. That plot of land which is stated in the clause number 18, Lordship. They are constructing another plot of land where they have not given me any profit to me. Lordship,
Who owns that plot of land?
Lordship,
Who owns that plot of land?
another prerogative is from society. That is not a I can make them party in the arbitration proceeding, Lordship.
No, whether you make party or not.
That
want
part-
to know that your arbitration clause moves from the agreement dated 31/5, isn't it?
Lordship.
Now, in terms of your notice, you are referring to clause 18.
Lordship.
Clause 18 says that you have given consent to some construction during
Yes.
separate land which are owned by two other separate persons.
Yes. That I have given, not in this process, not here.
But is there any bar, is there anything under the agreement to say that you shall not go for construction in any other land?
Lordship, that is true, Lordship. Here it has specifically stated as per clause number 18.
Have they not constructed have they not started construction in the clause mentioned in clause 18?
Yes, they have constructed.
They have constructed.
But they have constructed, but now my grievance is that, Lordship, my grievance is that they have constructed plot of land where we have not authorized. My construction, my bond of
No, you can't. Where is the question of authorizing? You are not the owner of that land.
No, they are also not the owner, Lordship.
They
They
may
cannot
not be. They may have entered into an agreement.
No,
separately.
but they cannot show my land. My contention is that they are showing my land. They have agreed in the objection also. They are showing my land. They cannot show this. We are a joint owner also.
You are
He-
showing where in the objection?
Here is the objection. Here objection part also, they are only one point also. Objection is in, that is that I am just referring to Lordship. Lordship can go through it. Their only objection is that this matter is not arbitrable. So that part is being decided by the Supreme Court. So I am not on the other part, Lordship. So they are admitting to the thing is that, Lordship, the appeal is pending. The session court has taken cognizance of
Appeal.
Appeal is also there.
Appeal against what?
Against the
My
section
lord,
9.
there was a section 9 application.
I find.
Interim
Initially, there was an
injunction granted.
interim. Against that, we had moved an appeal. Again, raising this issue of arbitrability. On that point, my lord, there was a stay. That arbitration appeal is pending against the 37. It's a 37 application.
37.
37. Because against the interim order, my remedy is 37.
37. They are in. Lordship, here
Against the orders, section 9 petition.
section 9 section. I got the interim petition, but my contention is that, Lordship, with all respect to this court, Lordship, honorable court, Lordship, here my only contention is that, Lordship, I am referring to that they are admitting that they are raising an issue that the matter is not arbitrable. So they are admitting that the arbitration clause is there. They are not denying that they are only from the whole part from section 9 to 18 part on their court also they are saying that the matter is non arbitrable. If that is so, then this judgment covers my case, Lordship. In that case, Lordship, may kindly appoint an arbitrator and decide the issue whether the matter is arbitrable, non-arbitrable, whatever it is, it can decide. So I am only praying, Lordship, at this stage, Lordship, arbitrability part can.
Arbitrability, not arbitrability. What you are saying, your argument based on the judgment which you have referred is not acceptable. Your argument that arbitrability, not arbitrability is a question not to be seen under 11.6.
Yes.
This is not what is said in the judgment. The judgment is an authority where the issue of which clause is arbitrable, which dispute is not arbitrable. There is any dispute, you should leave it to the arbitration tribunal.
Yes.
This is not the question. The question is whether there is any dispute at all to be referred.
I'm just trying to convince, Lordship.
First, you convince us that there is a dispute.
Yes, my submission is
That dispute must be referable to the
no,
regulator.
my contention is I'm trying to concise my submission, Lordship. If I'm not being able to convince, Lordship, here my conscience is that the land is in our land. I am the one of the owner, Lordship. So they constructed a plot of land, which is specifically says that NOC is there, GMBA permission is in my name, which says that they have to construct 110 flats, which is specifically limited to 110 flats. They cannot show my plot of land as a road to that plot of land. That is my
Where they have admitted, where have they admitted in the
yes,
objections?
Yes, they have admitted that part. Yes, Lordship. They are admitting page number 4, Lordship. Page number 4. They are saying that they have that among other clauses, agreement dated so and so, it is mentioned that the clause number was signed specifically provided for that second party. That is, the instant respondent shall be at liberty to merge the scheduled land with adjoining land in any side of it and construct for their own benefit. This is admission. This is being
Where page number?
page number 4.
4, clause number?
Para 2.
Para 2.
Or page number 9, Lordship, kindly go through it.
Clause 9.
Huh?
Clause 9.
Clause 9, page number 31. I'm reading it first. It should be written in totality, Lordship. They are giving a part of the
Clause 9, yes.
Clause 9. Then the first party shall hand over the khas and vacant possession of scheduled land, including the extra land, that is extraneous land, to the second party on or before registration of this instant deed of agreement and irrevocable power of attorney. The second party shall be at the liberty to merge the scheduled land with the adjoining lands. We are referring to that part which is referred in paragraph number 9 to merge
Where is the schedule? Where is the schedule?
schedule is in the that is page number 39.
What are your dark numbers?
This is
Where are the, where is that, where is that adjoining land
adjoining land. I have referred in the I have
in the
referred-
schedule?
It is not in the schedule.
Then?
Yes, that is the issue, Lordship. That is the issue. As because this is not in the scheduled land, they are constructing outside the scheduled land. Now using
What
this
is the,
agreement,
what is the meaning at the second line in para 9?
para 9, Lordship. Then the first party shall hand over. The second party shall be at liberty to merge the scheduled land. The exonia land, that is.
Scheduled land means page number 39 land.
Yes.
All right. With the adjoining land.
In any side of it and construct a proposed multi-story building for their own benefit and profit.
Then
Then,
you have agreed
that's
that
it.
you have agreed that they should be allowed to construct.
Yes, there should be agreed, not this this land. This land is not in the scheduled land. That is the issue, Lordship. This land which is being agreed
No, no.
agreed at
Clause 9 says that in addition to the scheduled land, they will be allowed to construct in the adjoining land in any site.
no, Lordship. The scheduled side at the liberty to merge the scheduled land with the adjoining lands
Adjoining land in
Adjoining.
any site.
in any side
Hmm.
of it and construct the proposed multi-story building for their own benefit and use.
Right. So on the scheduled land, the construction is already done.
Done.
Now in the adjoining land, you have agreed that they are allowed to merge the scheduled land with the adjoining land.
Not that scheduled land. Not that scheduled land. It is exonia land. This is from the you have the lordship has to read from the first part. First part is shall hand over the class and vacant position of scheduled land, including the
Extra land.
extra land. That is the exonia land of the second part. Before the registration and instant deed of agreement, the second party shall be at liberty to merge the scheduled land with the adjoining land in any side of it and construct the proposed multi-story building for their own benefit and use. But this part we have agreed on this scheduled land which is referred in this agreement.
It is not clear from the clause.
Lordship.
Clause says you will hand over scheduled land along with the exonia land.
Yes.
Then the second party will have liberty to merge the scheduled land.
Yes.
That means scheduled land along with the exonia land
Yes.
and merge it with other adjoining lands.
No, Lordship. Here, other adjoining land, they have that is not that is not adjoined. That has to be taken part. This agreement, this construction started in 2019, Lordship. So,
To explain, see, there is a scheduled land,
Lordship.
there is an exonia land.
Lordship.
You have handed over both.
Oh, right.
You have also agreed
Lordship.
that they are entitled to mention, they are entitled to merge the scheduled land along with all other adjoining areas.
Lordship, that part is being explained in page number clause number 18, Lordship. Which is being referred to. The second party, as the instance of first party, having obtained the work of development of adjoining land, adjoining land is defined in the clause number 18. Adjoining land, that is one kotha so and so and three kothas in the respectively so and so and so and so so and so so and so. This is come and permission for merging with the scheduled land as such a second party shall give flats or the so and so price the remaining area. So adjoining land is being defined in the agreement also.
Yes.
Adjoining land is being defined. So they have diverted, they have defined this agreement, Lordship. By defining this agreement, they have constructed the schedule now adjacent plat in 2019, showing our plot of land. My contention is that
You want to say that in terms of clause 9 and 18,
that's it.
they have constructed on the scheduled land,
Yes.
they have constructed on the exonia land,
Yes.
they have also constructed in this clause 18 lands.
Okay.
They have constructed.
Yes.
And you have been given your share of flat and price and everything.
Lordship. No, Lordship, no, Lordship, here the crux of the case is that, here the crux of the case. Here, Lordship, as because they have not purchased the land from us, as we have given the land, they have constructed the flat, Lordship. We are the joint owners. We can be considered as a joint owner.
How you can be an owner?
So it is a joint partnership, joint venture, you can say.
No, joint venture, you may
Land
claim-
will be always in my neighbors. Or land they have constructed. What's it? Even they
land will be in your name, but they have to hand over that portion of the land to the flat
yes, that
owners.
have to be. But here, Lordship, we always in for any consumer related cases also. Then also we are always liable because it is joint venture. So we are, because land is they have not purchased the land from us. From here, Lordship, leaving aside this part, I am not on to that, Lordship. I am on to that, Lordship. Here the dispute is that I have not given the adjoining. They have constructed in the adjoining plot. Or adjoining plot is being defined in the agreement. By defining that adjoining land, Lordship, they have constructed in another plot of land.
This adjoining land belongs to who?
Adjoining plot belongs to me.
You.
Yes.
You are the owner.
Yes. So I have handed it over. So Lordship, now what happened in 2019, they are showing our plot of land as a road. They constructed that plot of. This is purely illegal as per
So
GN.
you are saying that adjoining plot of land, no construction was made, which was handed over.
Oh, they have constructed.
They constructed.
Adjoining plot, no issue, Lordship.
Then how they can show this land to be an approach road?
Yes, that is completely illegal. I filed requisition also for him. Party to the GMK also. That is also going on. Several cases are pending also. That part GMK is liable. GMK is also made a Lordship. But here the Lordship, here they are saying that the issue is that Lordship, my friend is only Lordship, my Lordship is not relying this judgment. Lordship, my contention is that Lordship, the matter agreement, the clauses are there. So matter may be referred to the arbitration. That is my two.
First thing, you made a wrong statement that we are not relying on your judgment. We are absolutely relying on the judgment, considering the judgment placing. But you have not been able to convince the court that this judgment is an authority for the issue involved here. Issue involved here is you have not been able to convince the court that there is a dispute arising out of this agreement, which requires to be referred to arbitration.
Issue is in a simple Lordship. If I not
the judgment you are relying on, where the disputes were there,
yes.
High Court decided no part of the dispute arbitrable, part not arbitrable. That the Supreme Court says is one.
Yes, sir.
It is not the case.
Yeah,
You
Lordship,
have to first show us that yes, there
not
is a dispute.
I'm again trying to
You have to confine yourself to the agreement.
I'm confining
The agreement says scheduled land, exonia land, adjoining land.
Lordship.
Right? Scheduled land, exonia land you have handed over. Adjoining land you have handed over according to clause 18.
Yes.
Now beyond that, they are going for further construction in some other land.
Yes, accepting, considering my agreement, showing my
All
agreement.
right, they have sold your land as an approach road, etc.
Yes,
and have got a permission and everything. But there your remedy lies before the forum who is given the permission. You have to pray for cancellation.
We'll
Now,
do it.
from this agreement, where is the dispute? They have constructed. They've given you your share of money. They've given you a share of flat.
Lordship.
Now, in some other land, which does not belong to you.
Lordship.
Where
Yeah,
are you,
that is
where
the
are you,
question.
where
Then
is the
Lordship
claim
can-
made?
Lordship, kindly go to
On
my
what basis
my
are you
notes.
making the claim?
That's the crime. Yes, Lordship. Yes, Lordship is well aware. That is page number 76. 70. I'm going to the notice book. That is 11 Lordship. In the notice, I have stated that unless that Lordship, they are using my road for construction of that plot of land. That 70 flats of land which they have constructed now, they are using my plot of land. So they have to give profit to. That is my contention. That is my contention. That is that being undersigned calculated some losses to the tune of so and so, being partner entitled to a share of the firm. illegal act on the part of your firm, therefore same is recoverable from you, and my contention only dispute is that they are using my road, approach road, so they have to give profit. That is my dispute. That is the dispute. They are using my plot of land as a road. Yes, they are saying that yes, they are using it as per this agreement also. They are saying, they are not admitting in this agreement, and objection also on the whole part also, that I can show it also. Right? But while using my road, they have to give share to me. That is my dispute. So I am referring.
Where is that, where is it mentioned in the arbitration? Go and file a commercial suit. Go and file a money suit.
One of the partners had filed the suit.
No,
Then because of technical defect of only one partner approaching without consent of the other partners, that suit has been dismissed. As far as the permission is concerned, repetition is concerned.
in my opinion.
As far as the legality of permission is concerned,
Your question
repetition
is that since you had entered into an agreement, given them all facilities to construct, now they are constructing.
Now I cannot. Lordship, my submission is that, Lordship, my understanding is that. So my understanding is, Lordship, I leave it to your Lordship. My understanding is that they are using my plot of land where as a
We
road.
agree, we have understood your problem. They are using your plot of land, showing it
But
to be a road.
I'm saying that,
But
Lordship.
you are, according to you, you are agreeable to do that provided they give you a share of the profit.
Yes, now.
Right?
Yes.
Now you show us from the agreement where that part is mentioned. You are referring to an arbitration.
Yes.
Which is a creature of an agreement. From that agreement, you show us that there was an understanding that if you use my plot of land as a road or get an NOC, I am entitled to greater profit.
That is not there, but
Then,
that is the part here. Lots of one part here. Lot. I'm showing page number 38. Lot. Here, lot. I'm reading the 42 clause number. That part is also can be important. That any dispute arising out of these deeds shall be mutually resolved by arbitration.
any dispute arising out of this agreement.
Yes.
You show us that this agreement provides that
Yes,
any
yeah,
construction made by showing your plot of land.
Lordship, they are admitting that section 9 also para.
Oh, Mr. Counsel, their admission will not amend the agreement.
Lordship.
Agreement is what it is or
Yes,
what
Lord.
it is not.
Okay.
From the agreement, you show us that there was agreement between the parties that if you use my land for any purpose besides the construction and for construction of other adjoining plots of land, I am entitled to a profit. Show us from which clause.
That is not there. But
Then if it is not there, then where is the dispute? Where is the dispute to refer it to an arbitration? There is no dispute to be arbitrated upon.
Lordship, they are disputing. My contention is
You are making a claim that where I provided you with the land and the material and everything, you went and constructed another plot of land showing my plot of land to be a road or adjacent plot, but you did not give me the share of profits. That is your ground.
Yes, sir.
Show us from this agreement that such an agreement, such a intention was there between the parties.
Such an intention that is here. I'm
Your only claim should be, listen to the court.
I'm consulting my
Listen to the court. Your only claim should be that this agreement does not conceive of using your land as a thoroughfare or a road. Therefore, their NOC or their permission, whatever they have got it, by showing your land to be a thoroughfare is not proper. That has to be cancelled. Now that is not to be decided in an arbitration. For that, you go and approach the appropriate forum. The arbitration is that where the parties had agreed and one party has failed or defaulted in completing their responsibilities in terms of the agreement, that matter will have to be arbitrated. That there is some dispute, it needs to be arbitrated.
Lordship, here I leave it to the Lordship, but my contention is that, Lordship, here dispute is there because there is my agreement.
You show us from that agreement or any
Yes, Lordship,
covenants that your plot of land.
I'm just referring, Lordship, to clause number 40, there is an arbitration clause.
We have seen that. We have also seen the judgment.
Lordship,
We are asking you, where is the dispute? The dispute must be generated from the agreement between the parties.
Yes, Lordship, that is
Just as the arbitration clause arises.
no, dispute is there because they are showing my plot of, my agreement.
So where is that clause that your plot of land shall not be sown or used or anything? What you are essentially
No,
saying,
Lordship,
what you are essentially saying
Lordship, yes,
is,
Lordship.
is harboring on the parameters of fraud. What you are saying that they are fraudulent. Show your plot of land to be a thoroughfare.
Yes.
Right? And getting a permission that plot of land where they have constructed.
Yes.
You have no difficulty with that. So long they pay you. So you are a partner in crime. You are agreeable to this fraud, provided you are compensated by money. And that not having been done, you have come before 11.6. They are asking the court to refer you to an arbitrator. But from this agreement, that the agreement says that in case any such of the land or uses of the land is done,
that
then you are entitled to.
that intention is there when adjoining the land is being taken by them, Lordship. Clause number 18, Lordship. Clause number 18, as per clause number 18, they have paid us. Then Lordship, while using this part of land, they have not paid us.
Where is that? Which part of land? The adjoining
In
lands are defined in clause number 18.
No, Lordship, I am not on that part, Lordship. That this dispute is that, Lordship. I have made this development agreement for an arbitration, with an arbitration clause. That's it. That they constructed flats over our plot of land. That's true. That is one part, Lordship. After that, sorry. My submission and would be limited to that part. Was it that only this agreement, they have using this agreement for construction of a plot of land to that part of land, and here there is the arbitration.
Have you challenged the NOC or obtained by the respondents for the other plot of land?
Challenge.
Then you
There's a
challenge it.
repetition pending. There's no stay in that repetition.
But
It's
repetition is pending.
Not only
Lordship,
one,
yeah,
there are three
Yeah,
repetitions.
Lordship, only one part.
Against different statutory.
I am Lordship is convinced. Lordship is convinced in the dispute part. I am not being able to convince the Lordship the dispute part. That's then it's okay. But if dispute is there, my contention is that there is a dispute because they are using that plot of land.
No, that dispute is there. We are not saying that there can be no dispute. You have to show us that this dispute is because of their failure to honor the terms of the agreement.
What is that part, Lordship? My contention is that I leave it to the Lordship.
No, you don't have to leave it to us. You tell us. From the
I
agreement.
leave it to your Lordship.
You have entered into an agreement. You and the
But my
respondents have
contention is
entered
that
into an
Lordship,
agreement.
because there is an
From the
arbitration.
agreement, tell us that this particular clause was not satisfied. Clause 9 and 18 have been satisfied according to you.
Yes. But here, Lordship,
Only thing they have not satisfied is that
here, Lordship, here dispute arise, Lordship, here clause number 42, any dispute arising out of this, it shall be mutually resolved by the arbitration only. Here, Lordship, this dispute arises against because they are using my plot of land.
so where is it written that this plot of land cannot be used? That amounts to forgery. What you are urging is that this agreement or these plots of land are shown to be an approach road
Yes.
to get a permission or
Yes.
an NOC to make further construction.
But no, Lordship,
Right? There is no restraint in the agreement. But you are agreeable to this particular recourse taken by the respondents, provided they pay you something.
yes, Lordship,
Yeah.
they are showing my plot of land. That is, they have the profit, Lordship.
They made profit. You want a share of the profit. When you know that the approach road has been shown through your plot of land without your consent, but you are agreeable if they pay profit. Where is the dispute? If they have not paid you, There must be an agreement that if you use your land to make further construction or to show that it is
Lordship, in
pertinent
that
to-
case, Lordship, I have the request. Yeah, in my opinion, Lordship, my understanding, if they do not pay, at such a
let us simplify the arguments for your understanding. You and the respondents have entered into an agreement for construction, right? Now, there is a particular vehicle which the respondent owns, a beautiful car, let us say. You, the respondent tells you that if you agree to the clause and sign the agreement, I'll give you the car. But in the agreement, there is no reference to that.
Yes, sir.
You agree that yes, okay, I'll sign it, agreement signed, done and dusted. He refuses to give you the car. There is no reference in the argument. Will it be a dispute arising out of the agreement? You may feel cheated. You may file a case of forgery, fraud, 420, whatever else you want. But will it be a dispute arising out of the agreement? Because it is not specified in the agreement that in default what happens. Firstly, you have to define what he has to do, what you have to do, and in default what happens.
But here one thing is that Lordship, I have made a claim. Dispute is that whatever it is, they are using my plot of land, as a road to that plot of land.
That you are entitled, you have already filed some matters. You have already filed some matters. How will the arbitrator decide a dispute which is not born out of the agreement? You explain to the court that.
That part of that is
Assuming we accept your arguments that arbitrability also is left open to be decided by the arbitrator, we refer it to the arbitrator. But how will the arbitrator resolve the dispute when you cannot show that the dispute is because of the default of the respondents in terms of the agreement?
Lordship, yeah, that I can show you, Lordship. That part, what is there, Lordship?
You find it out, come back for further hearing on Thursday. Argument
I-
remain
What
inconclusive
is the date?
for further hearing on Thursday. 30.
30, I cannot know. On another, on 30, I can.
No, be there. You ask your colleague to be there. We have already heard you. You only have to
Lordship,
pass an order to dismiss your petition unless you satisfy us.
Lordship, just now. Lordship, may pass any order. Lordship, my contention is, Lordship is not convinced that.
Of course, we are not convinced because you are unable to convince us. You convince us that this is the dispute. It is mentioned in the agreement.
Dispute is that, Lordship. Yes, Lordship is, Lordship is right that this is a forgery is there, Lordship. Because there is the agreement, the permission is for the construction of the 117 flat, Lordship, or in our land. But they have now showing through our plot of land, they are using another plot of land. So their dispute is that I am claiming an amount. So they are
That you show from the agreement which clause you are entitled to make this claim. You must be entitled to make this claim first. Before you raise the flag of this default of the respondent, you must show that this is what you are entitled to get in terms of the agreement. Is it there?
the agreement, Lordship, admittedly, it is not there, Lordship. Admittedly,
If it is not there, you are not entitled. If they refuse, where is the dispute arising out of the agreement? Which will have to be referred for.
because they are refusing. That
They are
is
refusing because it is not a part of the agreement.
but any dispute, but here
Any dispute means any dispute out of the agreement.
Yes.
First thing, show us from the agreement, you are entitled to an amount. You come back on 30.
30, Lordship, I have some, 29 or 31, any date, Lordship. 31 I want.
No, 30.
April is in here.
30, Lordship, I have some functional problem. 30, Lordship.
All right, 7th. 7th of May.
7 May, I am not there.
You don't have to be there. Your counsel will be there.
Only I have to converse.
But otherwise, given the list of other cases that he has filed.
We are not concerned. It's a 11-6
as far as-
petition. We have to see whether
Only-
any
only
matter requires to be referred to arbitration.
Yes,
That's all.
Lordship, if there is no, I'm also understanding, Lordship, what wants to know, Lordship.
You have understood everything, therefore you have placed the judgment. Otherwise, you would not have referred to the judgment.
Lordship, I have my understanding is that, Lordship, these matters could have been decided by the arbiter.
Exactly. But what is to be decided by the arbitrator? What will the arbitrator decide?
If they have violated that clause or not.
That
That
will
part,
satisfy us.
that part I could not show now.
Satisfy us.
Yes, but they
Said
have
we-
violated the agreement, that part.
Satisfy us. That is what we have been asking you for almost an hour now.
Yes, Lordship, that right now that part.
On the previous hearings also, my lord, had come to this point only.
So we are giving him
Because
one
of
last
this
option.
illness, my
The
lord, the
matter be
matter-
listed on 7th of May. Let us see.
Only my
You ask your colleague to be present. If there is any submission necessary from your end, we'll
My lord,
consider it.
on the next date, 11th or 12th,
11th or 12th.
my lord. 12th would be better, my lord, because 11th is Monday.
All right, 11th. 11th.
highly obliged, Lordship.
Okay. Sorry, my lord.
Item?
Number 18. Territorial jurisdiction. So regarding my whether it is honorable High Court has a jurisdiction, try this case, my lord. We are relying on two judgments, my lord, and
There is no jurisdiction. Where is the jurisdiction? But you are working there, employer is there. Only because you are born and brought up here, you stay here, you want to file here. Only because Mr. Mahmood is from Gauhati, the jurisdiction has to be here. How can that be? That
So,
can't be.
a very detailed discussions have been made with regard to the judgment of Naval Kishore Sharma. I have given the every nook and corner of such type of cases have been discussed.
Now, who is the authority on whom the order is sought for? Which authority?
Commandant in Lucknow.
Then this commandant is in Chhattisgarh. It is outside the jurisdiction of this court.
No, that is, everything is there, my lord. And we go through the Naval Kishore Sharma judgment. There are 9 onwards. There are 9.
Yes, please.
Kindly see para 9 after third portion. On a plain reading of the amended provisions of in clause 2, it is clear that now the High Court can issue a writ when the person or the authority against whom the writ is issued is located outside its territorial jurisdiction. If the cause of action wholly or partially arises within the court's territorial jurisdiction,
What are you challenging here? Termination.
termination. And termination was
Termination
based-
order was issued on from Chhattisgarh.
Yes, but
You were posted-
report has been sent from the Assam Board of Secondary
You are not
Education.
challenging the report.
No, I am not challenging the report,
Then-
but we are the only maintainability of the matter. today I was.
Right. So what is that cause of action which has given, which, under which you feel that you can approach, you can actually come before this court asking for?
Because the dismissal order is passed from there. But now that authority has sought a report from the SEBA.
Right.
And SEBA sent the report. And on the basis of that report, I have been dismissed.
You are agreed with the report.
I am agreed to the report to some extent, but I mainly agreed on the quantum of punishment. Because the allegation was under
Mr.
section 11.
Mr. Counsel, first satisfy the jurisdiction point. Maintainability.
Maintainability.
Is it a case that you are challenging the report of the SEBA?
I have not done because there is some dispute. The person cannot say exactly what is the matter. So we are on that ballot when there are several types of punishments are in the CRPF Act.
You are going into the merits.
No,
you are going into the
regarding
merits of
cause of action, kindly let me
first tell us whether
Yeah.
any cause of action.
Yes. So here, the cause of action for the purpose of Article 226(2) of the Constitution for all intent and purpose must be assigned the same meaning as envisaged under Section 20C of the Code of Civil Procedure. The procedure or the Constitution, cause of action is bundle of facts, which is necessary for plaintiff to prove in their suit before he can succeed.
Therefore, we are asking you the same question. Your only ground is that the report of SEBA,
Yes,
according to you, is not correct.
correct or incorrect, that is another matter. But
Alright.
thing is this, the here from the report has gone from here. And on the basis of the
How
report,
is it a cause
part
of
of cause of action is here.
How is it a cause of action?
Yes, because on the basis of that, I have been dismissed from service.
That is not a cause of action.
But here, kindly say, so many judgments have been reported by the Honorable Supreme Court. In Paraten, in the state of Rajasthan versus Saikya Properties, the fact was that the respondent company having its registered office in Kolkata owned certain land in the outer skirts of Jaipur city was served with the notice for acquisition of land under the Rajasthan Urban Development Act 1959. Notice was duly served on the company at its registered office in Kolkata. The company first appeared before the special court and finally the Kolkata High Court, by filing a writ petition challenging the notification of acquisition, the matter ultimately came before this court to answer a question as to whether the service of notice under section 52(2) of the Act at the registered office of respondent in Kolkata was an integral part of cause of action, and was it sufficient to invest the Kolkata High Court with the jurisdiction to entertain the petition challenging the...
Ultimately, it was rejected that Calcutta High Court does not have the jurisdiction.
No, that was rejected. That was finally rejected by Supreme Court.
That's right.
Finally said that High Court was not right.
So does it go in your favor? Doesn't. Kindly see how is cause of action defined in Mullah? Very clear.
Kindly see para 19.
No, you please read para 8 first.
Para 8. While interpreting the aforesaid provision, the constitutional bench of this court in Election Commission versus Shoka Henkata Rao held that the writ court would not run beyond the territories subject to its jurisdiction, and that the person or the authority affected by the writ must be amenable to court's jurisdiction either by...
What are you reading? You read para 8.
Yes,
Para
sir.
8.
I will read para 8.
Expression. Not here in your para 8. Not there.
Yes. The expression cause of action is largely defined in Mulla's code of civil procedure. The cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court.
That's it.
In other
That's
words, it is a bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. The mere service.
Hold for a while. Now you tell us from this definition, under what context is the certificate from SEBA relevant? If you have to take this definition, then you have to prove that the certificate is wrong. Therefore, the authority could not have relied upon that certificate to issue your termination order.
But kindly flip last two paras, 19 and 20. Considering the entire facts of the case, last two paras,
Yes.
narrated herein above, including the interim order passed by the High Court, in our considered opinion, the writ petition ought not to have been dismissed for want of radial jurisdiction. As noticed above, at the time when writ petition was heard for the purpose of grant of interim relief, the respondents, instead of raising any objection with regard to the territorial jurisdiction, opposed the prayer on the ground that the appellant writ petitioner was offered an amount of rupees so, but he refused to accept the same and challenged the order granting severe compensation by filing the writ petition. The impugned order therefore cannot be sustained in the peculiar facts and circumstances of this case. In the aforesaid, the appeal is allowed and the impugned order passed by High Court is set aside and matter is remanded to the High Court for deciding the writ petition on merits.
Now here, what have you done from?
My submission is this. The Honorable Supreme Court discussed every pros and cons of the case. And lastly said that the High Court will hear the matter reference on merits. So maintainability question is settled here because so many judgments have been different.
Maintainability is settled on the facts of the case.
Facts of the case.
What were the facts of the case? And how are these facts similar to your case?
My case is similar. First thing, my lord, I appeared at Assam, Chirang district. In the interview, I was selected. I was processed in various places, including.
You are not challenging the recruitment process.
No, that is not. I also served at Khanapara. So, in this manner, my lord,
You are challenging the termination order.
termination order, the excessive punishment.
All right, excessive punishment, termination order, which was issued from Chhattisgarh. Where were you posted then? Where were you serving when the termination order?
That was in Chhattisgarh.
Chhattisgarh. So it is not in the case which you are referring here, is that the person had returned back to his native place. He had several correspondences. His application for disability pension was rejected and communicated to him in Bihar. So therefore the court said that cause of action, part of the cause of action arises. Here the only question you are asking for is lesser punishment, number one.
Part of a cause of action is a wide issue.
That's right.
Various
So
times,
which part
various
of,
places, cause of action may take place.
that's right. So if you go by the traditional definition, it must have that particular fact which you have to prove in order to get a judgment in your favor. What is it that you have to prove here? Let us say.
Regarding the civil procedure courts, what your lordship has indicated, Mullas, but in a civil case, suppose I have a land at Gauhati and some land also at Dibrugarh.
No, let us not go into those fictitious examples. Just confine to the facts
but
of your
any
case.
of the code, no, that is the it's a relevant question here. In three or four places, a person has land, but one court has jurisdiction. One court may entertain the petition.
No, please give reference to facts of your case.
My case is at
You have only raised two ground. Number one, that the report has gone from SEBA.
Yes.
Number two, you are otherwise a resident of this place. That is
But I also served at.
Those are irrelevant today.
Those are not relevant today, but it appears that all India, it is all India service. So I think this question of jurisdiction should be taken leniently.
You find out more judgments on this if you have. But these judgments that you are relying on, is on a different, the facts are more elaborate.
Maybe done, but another judgment we do have. Rajendra Singhal, that is 2010 1 SCC 457.
Yes.
2010 1 SCC 457, para 9 and 10.
Yes.
Now let us go to para 9 first. Para 9, the first question got it?
Yes.
The first question that arises for consideration is whether Andhra Pradesh High Court was justified in holding that as the seizure took place at Chennai, Tamil Nadu, petition before it, the High Court did not examine whether any part of cause of action arose in Andhra Pradesh. Clause 2 of Article 226 makes it clear that the High Court exercises jurisdiction in relation to the territories within which the cause of action arises, wholly or in part, will have jurisdiction.
Yes, in order to save time, we'll tell you what is troubling us. It is not your case that the information going from SEBA is incorrect, which they had relied upon and resulted in your termination. You did not have to challenge the report. At least there must be some averment to say that this report is incorrect and you are able to satisfy the court.
That lordship not a short time may be given. That means charge some other judgment, as well as also if necessity arises, then we will file additional.
Yeah, additional affidavit provided you have the material for that. So the petitioner seeks further time. Instructions. Factual issues. Right thereafter, Mr. S.S. Roy. Appears done at CBC, appears to the respondent. We wanted to hear your junior.
Lordship, I've given that.
But she's adamant that no, you have to argue the matter.
Lordship.
She's informed the court that you have stopped her from arguing the matter.
No, I've asked him.
Yes.
28, 29 by other than they have requested me to.
This is item number 18.
28 and 29.
Item 18. 18. So 18 we'll have it on 19th of May.
Lordship.
19th of May. Earlier, party had the matter. Some time has there. So I'll just briefly take a note. What happened in the year 2012? Life will decide. Thereafter, to a proper selection process, they were selected as assistant professor in contractual basis.
fixed salary of 44,000. Thereafter, your lordship, they contract was reduced, salary was upgraded, and after more than 2 years of contractual service, responded to a press advertisement, got regularized in the same post. And according to the AICT rule, after 5 years of service, contractual as well as regularized, they became eligible for promotion upgradation from grade 6,000 to grade 7,000, financial upgrade. So they approached the concerned authority, and there was no response. They pursued the faculty representative of Board of Governors. Finally, went up to the Board of Governors, and Board of Governors gave in principle approval. Document kindly come to page 70. 70.
So the proof.
They were selected in contractual. Clause number 6 of the AICT notification was also dated 8.
So ultimately, their claim for promotions were approved.
Yes.
For the from the year 2016-17.
Yes, sir. 2012 to 2017, 5 years first upgradation. It was approved. Next part, Your Lordship, I'll just show that petitioner 1, 2, and 3. 3 is at serial number 5. 3 is at serial number 6. 1 is at serial number 8. Also, the joining date and join contract. And on the date they were agreed. They were all above 2 years. Your Lordship. I will come to that, Your Lordship. So their contractual period is above. Next part, Your Lordship, of the minors. There was presented the BOG members for their consideration.
We read it, Mr. Rajkumar. That's what I'm saying.
Lordship.
That has been approved.
That has been approved.
Right. Then
Your Lordship, the 3-member committee was, they say, further scrutinize their credential. That is whether they have 1 year of contractual or more than 1 year. 3 members committee has to look into their credential. That was the mandate of the 3 members committee. Otherwise, in principle, the BOG had given that. Now, Your Lordship, what has happened? Thereafter, Your Lordship, subsequent BOG, nothing was placed before the Board of Governors. Finally, at page 113, we received an email of the Register of CIT. AICT notification number so and so dated 8 November 2012. Committee recommended contractual fixed pay is not considered for upgradation. The institute already adopted by order number so and so dated 31st January 2007. They refer to the order saying the contractual scale was accepted and contractual fix was not accepted. This order will be the next period, 115. So upon receiving this email, we gave a representation. Kindly come to the
order at 100. And then pay 150. Promotion order. Pursuant to the approval of the chairman. Number 2014 of MHRD New Delhi. The economic base pay of the following faculty are hereby upgraded to 6,000, 7,000 on the base. We are relying on this order, which talks about the notification of 2014. Now, this is not any rule or regulation. It's a promotion. Try to find this notification of 2014. Not find any notification of 2014. Almost similar number and similar date, except this is a notification of 2008. Our case, you will see 2012 notification, our 2019 notification. We have taken up this in our petition, you will see. Their responses were, no, they said they did not say anything. There was no response, no comment. Now, Lordship will kindly come to the AIC notification. Okay, here, Article 370. Yeah. What is your prayer? What do you want? My prayer is for the upgradation of which the BOG in principle agreed to. They have agreed to, but that was not given. That was not given. What is the reason? The 3 members committee said that we are only considering contractual scale and not contractual fix. Your Lordship, I will kindly turn to page 86. That will clear. 6. So they are not considering the contractual period, my 2 years of contract. Page 86. See number 6.1 F, Your Lordship. Services. Right there. My contractual period is less than 1 year. That will not be considered. But in our case, all are above 2 years. This is important. Ad hoc or temporary service of more than 1 year duration can be counted, provided that the service was more than 1 year duration. Incumbent was appointed on the recommendation of incumbent was selected to the permanent post continuing the ad hoc or temporary service. Number 4. Artificial break in service shall not be used the prestige of employee. Person appointed on permanent
considered by him with effect on the date of initial appointment. Temporary break ad hoc, notwithstanding the artificial break of the break. Here from F4, that ad hoc contractual or more than 1 year will be considered along with as your lordship will absorb in the same course regularly. Stand of the respondent. Those were textual minutes, they are not considered now, those scale minutes are considered. That is the case.
What is the difference between the
If they are getting regular scale minutes and contextual is fixed amount. By the BOT. Let's say contextual fixed or contextual scale. Or temporary. It is more than one. Contextual is more than
No, but was this not a point of consideration before the BOG?
they have already, based on that only, your lordship. The 3 members committee finding will all document. Already approved.
It is deemed that
Yes, that
their
is-
services were under consideration.
Yes, but there is one minute, 2018, there is minute. Is there minute, I next IM and earlier minute, not in minute,
IA.
IM minute is already disposed of minute. Disposed of. IM minute is, IM minute 4050-2024. It's already disposed. Page 41. It's payment. Contract member submitted a referendum to increase their grade pay next to higher. However, members denied the proposal as stipend that during this period of their contract year drawing salary of fixed basis. But the grade pay was not allowed, madam, to here, madam. They applied for the grade pay, madam. Contractual, those contractual, but it was denied, madam. Those were contractual fixed amount. Because of this only that we approached the academic committee. Because our case was that the regulation of the institute cannot supersede the rules of the AICTE. They're born out of the AICTE. So that is why we approached, and finally we went to 20
fifth BOG in 2022, and 2022 fifth BOG appears 101. They said yes, in principle, following your clause 6 of the regulation, they should have got the promotion. Only thing is look into the credential, the 3-member selection committee is going. Now, if your lordship will kindly take up the selection committee decision. Final revision 525, where we have brought on record the decision of the 3 members committee. And in fact, that decision of 3 members committee was not even placed by the registrar before the Board of Governors. That is true. They placed it before the Board of Governors. Now, placing that, the registrar informed to email that your case has not been. That our additional affidavit dated 525 at page 256. As serial number 2 level. That's the issue of the 11 faculty members. November 2012. Refer to the 2012 notice. Then they come to the conclusion. Committee recommended that the cases of contractual within bracket fixed pay not be considered for upgradation, as the institution has already adopted contractual on scale for upgradation by order number so and so dated 31st January 2013. Now, the 31st January 2013 order was only a promotion order. It's not any rule or regulation. So on one side, they are referring to the regulation of 2000. And they said contractual scale is accepted, not fixed. Whereas the AICT regulation says that ad hoc, contractual, and temporary will be considered as long as the contractual period is more than 1 year. And since our period was more than 2 years, that is why the BOG on 25th BOG on 2012, 2022, your lordship, they gave that to consider that. Consider you please. In the BOG, simple. What left? What is required to be done? Nothing is there. Actually, lordship, now the 3 members committee should have placed it before the Board of Governors or our credentials. And it was the BOG should have decided, your lord. This 3-member committee is in pursuance to the BOG's resolution that they will examine the credential. What, so this 3-member committee appears to be to have resolved something in contrary to the BOG. I'm grateful. That is my case. Yes. And it was not placed by the registrar. Yes, madam, that is true, madam. Only madam, there is madam, one letter, madam, 206, madam. It's a committee report accepted like this. Here is the one sentence, madam. The committee report is accepted like this in my additional affidavit filed on the page 206, madam. That much. Is that?
It is an institute, technological institute. All technological institutes comes under the AICT. Being a deemed university, only after 2000.
Where are the act or the statutes, the statute? Where is Board of Governors? Fine.
What if I may say? Doctor. AICT.
There is no disorder. Your Board of Governors have approved in principle.
They have approved.
Now, under what statute or rules does the Board of Governors confer the powers? What is the role of the Board of Governors?
The AICT Act is there, Your Honor.
Governors of CIT Kokrajhar. That ad hoc services are to be counted for.
Yes. That is there in the next year. We are relying on this.
Six. Say career advancement.
Career advance. Economic stuff, in technical. Regulation may be for the all India council.
Where is the aspect of ad hoc service?
That is at page. Where number 6, page 86. For temporary service.
All right, we'll dispose it off, we'll pass orders to the, who is to pass the order? After the BOG, who the authority will pass the order? Registrar.
Registrar.
But
Director, right?
council.
Director.
Petitioner.
Director.
You are presently serving as what? assistant professor, serving as assistant professors, Central Institute of Technology, Kokrajhar.
Our-
Central University of
Only our case will be for professional platform. They are not entered and still there. That's different.
Central Institute of Technology, Kokrajhar is a deemed to be university and Ministry of Education, Government of India. Established as a sequel to the Memorandum of Settlement of the Toro Accord signed on 10th of February 2002. Settlement is done by an autonomous body registered under the Societies Registration Act 1860 and functions under the Board of Governors. So, petitioners had applied for rendering for being appointed post of assistant professor CIT Kokrajhar pursuant to advertisement number 8 of 2012 dated 11/7/2012 issued by the registrar of the CIT Kokrajhar. Stop. Appointed assistant professors CIT on contractual basis for an initially for a period of 1 year. Number 1, appointed as assistant professor Department of Science and Engineering. Department Sir, 4 and 5 assistant professor in the Department of Civil Engineering. Lordship, 4 and 5 have given, no, so it's only 1, 2 and 3. 6 was the was appointed as assistant professor, Department of Basic Science and Mathematics. Plans of the petitioners are that they having completed required years of service, their cases are to be considered for C2 promotion. Are required to be given accordingly. Supervised and governed in terms of the provision laid down by under the BAC Act 7. So, by the AICT are binding all technical institutes. Filed by 6 petitioners presently. By petition number 1, 5 and 6 bring their claims. Learned counsel for the petitioner has referred to the AICT regulation. Specified under clause 6, and therefore their past services on contractual rendered on a contractual basis are required to be taken into account. career advancement. Potential before considering the promotion. Constituted pursuant to the aims of contractual consideration for promotion. Career advancement. Praying for a specific direction. The respondents to consider their cases and grant promotions under the CS. The respondents have contested the case by filing their affidavit. Affidavit filed on behalf of respondent 3. Stand has been taken. The respondents have objected to the claim by saying that by adopting the stand that promotion to promotion under CS cannot be considered aspect of rendering services on contractual basis. Services on contractual basis of fixed pay. Had they been receiving contractual, had they been rendering contractual services on scale, then their cases could have been another contractual salary on scale. Respondents have been rendering their services on a fixed pay. The outset, it is seen that the CIT, Pokrajhar, is a technical institution. Therefore, parameters laid down by the AICTE Act of 1987 are required to be followed by all technical institutions. Under the AICTE Act, under section 2H, G, H, whether writing technical information parameters six thereof provides for accounting of past services for direct recruitment or promotion under CAs. 6.1 within bracket F categorically provides that ad hoc or temporary services for more than 1 year duration can be counted and subject to the condition 6.1F instructed below. There is no dispute raised or there is no dispute raised by the respondent that petitioners have not completed 1 year of contractual services. So, AICTE norms specific meeting on 17th of March 2022 regarding the promotion of contractual faculty members joined in the year of stop. Said resolution, said meeting, so that the petitioners that the 11 faculty members whose names are listed herein, and which includes the petitioners 1, 2, and 3, were found by the BOG to be eligible for promotion from 16/17 onwards, considering their contractual service periods. However, due to unavoidable circumstances, they did not receive their expected promotion in time. This is the categorical adopted by many people. The BOG also thought that committee they constituted to further scrutinize the credentials before considering. Comparison of the resolution that BOG has categorically like has accepted the entitlement of the petitioners for their promotion, but which could not be granted. So no dispute that the petitioners and other similarly situated persons will be referred in contractual basis, whether on scale or fixed term. So, how three-member committee is constituted pursuant to the resolution adopted by the that the institute had already adopted contractual whether on scale. Minutes of the scrutiny committee, three-member scrutiny committee. 5, 6. There is no averment in the affidavit filed by the respondents that the three-member committee constituted pursuant to examine the credentials pursuant to the decision taken by the BOG. Take a decision contrary to reference to appropriate minutes. Fixed salary be entitled for promotion. Entitled for promotion of this year. That for IIT Supernumerary is competent to the spectrum service condition. Minutes of the I think so, they both of them. That there is no spelled out in the AICD distinction. Contractual employee, like a skill, and contractual employee. Categorical permits. Rendered under ad hoc or temporary service, provided it is for more than 1 year, it can be counted. For the faculty member. So submitted in the course of the hearing. Of the hearing. Such circumstances, where under such circumstances, the court has to accept the contentions raised by the petitioner that their cases being considered and approved in principle by the UG. Yeah. The committee of the members constituted pursuant to the resolution adopted by the BOD to examine the credentials of the faculty members, including the petitioner, cannot take a decision contrary to the decision adopted by. However, open to the BOD their earlier decision and take any such decision if otherwise permitted in law. So, but from the pleadings available, material has been found suggests that the BOD had revisited or earlier taken such circumstances. The claims of the writ petition, particularly writ petition 1, allowed respondent number respondent number 3, Director Central Institute of Technology, Kopraja, will take steps without any further delay for granting the benefit of promotion and CIS to the writ petitioner 1, 2, and 3. Terms of the resolution adopted by the once benefit of promotion and CIS. I am prepared for respondent 1 to 5 months, and my rest my friend private respondent, they are private. Private respondent number There are private respondents.
Yes, but because they are already received contractual scale manner, so they are considered.
They are challenging their appointment.
No, madam, no.
Then why are they responding?
Well, because of their interim orders, their so earlier it was bracket. It was bracket earlier.
Mr. S.K. Mehdi, Colonel CBC appears for respondent 1 to 5. MS D. Das appears on behalf of respondents 6 to 36. Since the private respondents 6 to 36 have already been promoted, they are promoted.
They are you already allowed
Since there is no claim made by the petitioner against. Why were they arraigned? They have not made no claim.
They have included your
They have included.
earlier there was interim order.
The respondents 6 to 36 are the included respondents against which the petitioner.
Right. DPO.
What
Yes,
is the
madam,
matter?
I'm challenging, my lord, may kindly take up item number 27.
27.
Yes, madam. Page number 68, my lord.
What is your claim?
My lord, I'm praying, this is the gradation list that I'm challenging. my lord. This gradation list is the final gradation list of Suveda of Home Guard organization, my lord. And here I'm challenging that my juniors had been made senior in this final gradation.
Who are the respondents?
My lord, the state is the respondent and the private respondents are also presented.
Who are the private respondents? In item 27,
In item 27, my lord.
you only see the state respondent.
After that, my lord, we have completed, my lord. In page number 69, the final gradation list, Samidal Kumar Brahma, Indrajit Hosna, and
But
Devajit
these for the respondents. Private respondents will be affected. According to you, your
Yes,
name
yes.
should be above them.
Yes, ma'am.
Then where are the private respondents?
They have been already included in this matter, my lord, by way of an agreement creation. Last one, my lord, it can be seen the cost item, my lord, is there. There it is presented, my lord, and even an affidavit has been filed from their side.
How many private respondents are there?
My lord, as far as this item number 27 is concerned, there are total 3 private respondents. And as far as item number 26, there are total 27.
But where are the counsel for that?
So, P. Sinha, he has been not appearing for last 2 occasions. Whenever the matter is listed, he is not present.
All right, some other day.
It may be given.
Don't worry. Come when it's on, whenever it comes.
My lord, because there is an urgency. The urgency is, my lord, this body is under the Home Guard organization, these people. And right now they are being brought
Yeah,
under
every
the.
matter is urgent. See, we are not able to complete the hearing list. Every matter is urgent.
My lord, the last
Admission urgent, hearing urgent. How do you complete it? Somebody will have to. You are arguing a matter, you don't know who's representing the respondent. You want
No, I'm saying, my
seniority needs to be interfered with.
my lord, I'm saying that. I'm saying that Mr. B.P. Sinha is the counsel.
But
Yes.
there is no indication here that somebody has represented the respondent.
It is there in the subsequent order, it is there.
Subsequent page, page 20, item 27. Anyway, some other day.
Malad, kindly a date may be given. It's a humble prayer, my lord. After much persuasion, I have listed it.
28th
Yes,
of
sir.
May.
Yes.
28th of May.
There is an interim order that may be.
Interim order passed early will continue in the next day.
I
Yes.
oblige, my lord.
Manoj, item 28 and 29, Manoj. Can it be taken about 28?
28. 28 and 29.
Manoj.
28.
28 4. 28 4.
28 for, no,
30.
28 of May.
That will be, some urgency is there. Manoj.
30.
Fine, Manoj.
But it's hard.
What is partnered matter?
Not
Yeah.
hard, but
But several times they also had the matter. So in that
Then-
view, it is part of.
Then it can't be next week. It has to be some other time. If it is partnered, it has to be on some other day. If you say it is partnered, you'll accept it. If you say it is not partnered, then you can list it.
not part hard.